Boom. Hello, everyone. How are you doing? I hope everyone's doing well. Um, I am sorry. Uh, I was kind of robbing it up here. I'm a little bit late. I'm about 3 minutes late. So I hope everyone is having a wonderful day here. I'm a little tired. Um, Kurt, I see you saying that you can time people out for a full day. Use your powers wisely. Use them for good. Um, I'm watching you. All right. So, I guess top of business is a chat that I just got here. And this is not a super chat. This is just I was looking over the chats here, and I thought this one was one that definitely needed some attention. I also need to be in focus as opposed to what I'm doing right now. Give me a second. I don't know why I'm so fuzzy, but I need to unfuzzy. Fuzzy is bad. So give me 1 second here while I unfuzzy for a very important announcement. Um, I was having a nap and I hit the snooze button, and then the alarm went off again. And I went, "Oh right, this was not the day to hit the snooze button because I got places to be." So let me just fix the fuzziness problem. That's from my lovely webcam, which thinks that the good idea is to be way out of focus at all times. There we go. That should fix it up. All right. Now, I see somebody saying, when will we be doing Monday Illegal Fun Day? I'm not allowed to do that. Not since the incident. So the first thing I want to do as first order of business is this one. Can we get a shout out from Ian for Kristen PSB, who's listening whilst in labor? That is incredible. Congratulations, Kristen PSB. I hope everything goes smoothly. I will not tell you the horror stories I'll tell you the horror stories a little bit of when my mom was in labor with me, which was that it took so long that eventually it was just like, screw it. This is becoming a C-section. This is taking way too long. So, hopefully everything just goes smoothly. Kid comes out like it's a water slide and everybody is happy. So, I'm cheering for you, but to the extent that it's going to be any longer than that, I hope that this helps makes things a little easier. Maybe, probably not. I might be being a little overly optimistic about my powers. So, and we also have an early review here that I want to talk about here. People are saying, what incident? It's a joke, folks. There was no incident. It's a joke. So, what is it? I also want to give a little shout out here to this member chat here from Cookie Mon Steve. So if you're not familiar, Cookie Mon Steve was the winner of he won in the auction for the charity donation. He got the underbarrel hot sauce holder that was used for that was used in this, and was used basically for my Get Ready With Me video. By the way, that video is up for a Gundy for top video of the year. So go vote. You can vote once every day. We are in the final weeks. So go vote on that if you can. That's at thegundys.com. But so I had this little this leather thing for under my shotgun to hold a bottle of hot sauce. So he won that, and I sent that out to him. And I had noted during the auction, I said, listen, if you happen to be in Canada, I will send this with some hot sauce, because I've got some hot sauce I've made, and the problem I'm having is that I can't ship the hot sauce to the States right now, and it's gonna get very quickly to be too cold to ship it within Canada. So But it was just in time, so I got that sent out. It arrived. It didn't freeze. It didn't. There were no issues with that. And so this is, I guess, an early review of the hot sauce. Everyone makes mistakes is definitely worthwhile. So that is good to know. I've had some reviews from people who now, I mean, the problem with the reviews is that it's always difficult to know if people are like, oh yeah, this is great because they're fans, or if they think it's actually great. But so far, I've been hearing that people think it's pretty good. I met with some fans out in San Antonio. We did a little impromptu thing, and I brought a little bottle of hot sauce. So the little bottle of hot sauce was, we shared it out. People were trying it very gingerly, and people seem to like it, which is good. I'm hoping that people will continue to like this stuff once I get it into proper production. I also have a couple of ideas that I'm thinking I may try to make happen. So first, I guess I got to get all of this hot sauce I've got sold. But once that happens, I am going to be looking at. I've got some other ideas for hot sauce ideas, so I'm going to see about that. All right. So, let's talk about some other things as well. Some of you know I have a merch store, and I don't normally sort of advertise the merch store a whole lot because, quite frankly, my merch game is weak, very weak. So, but we just had an announcement from Rob. And Rob is probably not going to be able to be on tonight. He's not feeling well, so he's going to be here in spirit / possibly in the chat. Possibly he's just going to be sleeping because, that's a good idea. But Rob Lawn Lumber, if you've been watching his channel, you will know that he just made a recent announcement. And that is that he's gotten engaged. So, I have, in honor of that, developed a shirt. And so I'm just going to share the image of this shirt, and I'll share the link as well. Let me just drop the link into the chat here. And so there we go. And I just got to, 1 second, I got to stop that from making noises. If you heard that on your microphone. There we go. Let's... So this is a shirt to commemorate Rob's engagement, which, if you'll note here, it is a women's shirt. You can technically order it in non-women's shirt, but the text there says, pour one out for the thirst. Because there's going to be a lot of thirsty people who will be very disappointed about this one. And I am sorry for the, to the thirsty people out there. But you might be saying, why are we, why is there, why are you doing this? Well, I don't know. Do I still have the thirst? Do I still have the thirst clip? I think I do. Give me 1 second. This is the thirst clip. That is the that's the rated G version of the thirst clip. There's another version that Rob has banned me from ever playing again. But so yeah, every time people took the, every time Rob took his hat off, you'd get people being thirsty in the chat. So, hence the shirt. Now, what I'm planning on doing with this, previously my merch store raised about $8 total, like across its entire existence. So that is not exactly that is not exactly a huge amount of money. I'm hoping that more people will have interest in this shirt, because what I'm hoping to do is then turn around and use this shirt, like use the money to get Rob a gift, Rob and Mischief Manager a gift. And the gift will be addressed as from the thirst. And the more people buy shirts, the funnier that will be, because at the end of the day, it'll be hilarious if Rob ends up with something that is like ridiculously over the top, and especially if he ends up with something that is nicer than than what I get him as a result of the thirst. So now I'm seeing people say play the original. Let me see if I can find the original thirst video. And then Rob is gonna have opinions when he finds out. So but let's see if I can find it here. Where is it? I've got the scary clown video. Rob really hates that one. Like that one he really hates. Let's try this one. I don't know. This one might be the non-G version. I'm just uploading it here. Uploading. There we go. I've seen people say, not the clown. I won't play the clown. The clown is really, I can use it for one thing, which is that if Rob is in the chat and I need him to not be in the chat so that we can talk about things behind his back, like, secret wedding plans or something, then I could play the clown a couple of times and I know he's not in the chat anymore. Of course, neither is half the chat. At that point, it's just like, well, I've scared everyone away. I am talking to myself, and now I can do my evil scheming. Somebody in the chat said, you better be invited to the wedding. And I will tell you, I invited myself to the wedding. I said, Rob, I'm coming. And he said, of course you're invited. And I said, doesn't matter. Like, if I'm invited, I'll show up in a suit and a tie and all of that. But if I'm not invited, I'm showing up in a ninja outfit and the tie, which would be awkward because that is a bright yellow tie. And so if I show up in like a full ninja outfit and the tie, I'm going to have a really hard time sneaking out. But we're still going to give it a try. And I may have to show up in the ninja outfit just because it'll be funny. So I think this might be the original thirst clip. Let's try this thirst swoop. That is the original thirst swoop, which Rob has banned me from using. So yeah, people are saying show up in a clown's outfit. No, he would come after me. So all right. So that's just kind of that. I linked that in the description. Now let's see. I'm just trying to juggle things on the back end here. We got a bunch of stories to talk about here. There's a whole bunch of things. So I'm just going to take this one down while we put up something else. I guess there's a few things I want to talk about, and where do we begin? Because there's a whole bunch of stuff. I see Rob can only ban that on his channel, not your own. I mean, that's debatable. I don't want to get myself de-invited because those ninja outfits probably itch. So yeah. Now Equality is saying, are you going to talk about the Calgary cop video? For the people who don't know, there was an incident as a traffic stop that was posted to Twitter, and people are asking, am I going to cover that? And I'm going to tell you that I am not. And the reason why I'm not The reason why I'm not covering that one right now is because the guy has a bit of a potty mouth. And by a bit of a potty mouth, I mean he uses the F word like I use salt. And to put this into context, I have been known to eat dishes for, that have been salted to a degree that my wife considered them to be utterly inedible. So, we're not doing that because that would get me probably yanked. And somebody says the cop or the guy pulled over. The guy pulled over. The guy pulled over was swearing up a storm. Instead, what I think we'll start with is we'll talk about some gun stuff. Specifically some Canadian gun stuff. And I know people are going to go, oh God, no, Canadian gun stuff. Don't get Runkle started. Well, too late. I've been started on that for a while. And so what we're going to talk about to start is the announcement of a tender for the buyback. Now, I'm going to have to make a video on this in some full detail. We're only going to cover the funny parts of this right now. And Greenwood Fire Response, post the question. So as you probably know, the Canadian government banned a whole ton of guns, including the AR-15, but also things like rocket launchers. Now, rocket launchers have caused 0 homicides in Canada because they're stupid expensive, and the only ammunition you can use in them is training ammunition, and like you can't actually get the explosives. But they banned those, which is going to affect some World War II military collectors, and that's about it. And I'm being told I have to swoop. I always forget the swoop. Let me swoop. Doggo swoop. Doggo swoop. All right. So what we have here is this is basically an invitation to qualify. It's the firearms buyback program. And so this isn't really a call for tenders yet. It's basically that you can submit a proposal in order to pre-qualify, in order to be qualified respondents for the later phase of the procurement process. What does this mean? It means that when they do the actual procurement process, they're going to want to keep it as hidden as possible. They're going to want to not have it public in the same way. So you have to get on a list to be an official gun buyback person. So, yeah. All right. So, let us look at what happened, because there's a section of this that basically invited people to submit that they are an interested business for partnerships. And what that meant is that anybody could submit to say, I have a business. I am interested in partnering with other businesses in order to get involved with this. So, that resulted in a thing happening because people thought this was the greatest thing ever. And let me pull this up here. There we go. So people started submitting various entries. As you can see, some of the entries are Communists Get Bent Limited, Rob Ford Crack Fund, LLC, Zelensky Incorporated, Charlton Heston, LLC, Treasonous Liberals, LLC, Trudeau is a Failure, LTD, Trudeau for Prison, LLC, I'm with Fire Trudeau, LLC, Fire Trudeau, LLC. They should have realized that people thought this was going to be hilarious, and in fact continued to post. Now, some of the things people posted were inappropriate to a degree that I'm not putting them up on a live stream because YouTube would have opinions, and I'm certainly not reading them out. But that said, people were poking fun at it to a great degree, and I appreciate the general sentiment of people poking fun at it. And so the eventual result of this is that now partner with another business indicates the functionality to add your company name to the list of interested businesses is temporarily unavailable. Whoops. Sorry, guys. Yeah. Somebody said all the Trudeau ones are Runkles. They are not. I didn't post any of them. I just took screenshots because it was funny. So, yes. That's all I did. And some of those screenshots, some of the screenshots were mine. Some of them were other people's. So I'm not sure which one was mine and which one was someone else's. But yeah. So that's fun. I approve of mocking that just a little bit. I am going to do a video at some point in the near future talking a little bit about the procurement process here and what that means. So, what that means for Canadian gun owners. It does look like they are moving forward a little bit on this, and that is sad for those of us who enjoy freedom. So, I see as Viva Fry got an alibi. No comment. I don't think we're going to get Viva Fry into any trouble here. That would not be cool. Now, there's some other stuff that I don't know if I can post on YouTube. Maybe I can find some of the things. I got to pull some of these off my phone because I had them up and then my phone got disconnected and now I don't have them up for displaying. But I had fun. That shouldn't be something that sounds like it's kind of an epic epic thing that never happens. That sounds depressing. But I did have a lot of fun. I have fun at other times, but I had fun on this occasion specifically. So I went down to the United States for an event at Demolition Ranch's new facility. And if you don't know who Demolition Ranch is, he's got a great channel out there. It is a channel that shows all the gun sorts of things. It's this guy, Dr. Matt Carricker. He's now, if you don't know where he is right now, he is at his ranch. He's at the range, and he's standing on a thing. He is standing on a vehicle. This vehicle was donated by World of Warships. And this vehicle was, I'm just going to pull this down so I can pull up another picture here. This vehicle was a fully loaded Humvee. Fully loaded. And, that is kind of impressive because they donated it to be a target downrange. And, yeah. So if you're thinking, hey, I could use a fully loaded Humvee, well, you might want to look elsewhere because this particular fully loaded Humvee, and they did ask, they said, hey, our sponsor, World of Warships, donated a Humvee. So please try to say the World of Warships Humvee if you possibly can. So I'm going to keep saying that because it was nice of them. And, when somebody does something nice, you might as well. Now, I am not really a player of World of Warships or any of that sort of online game. But this is what happened to the Humvee. I would show you the video I have of this happening, except YouTube would ban it. Now, you can see that this Humvee is riddled with holes. Very little of it, if any, survived. Somebody got into the Humvee and tried to start it. They found the keys to the Humvee. They were like, "Where's the keys?" And they got them in, and this Humvee does not start. It doesn't start. So yeah, Humvee is an ex-Humvee, and I mean, we're not going to mourn the Humvee. It was a good car while it lasted, but you know, we're not going to mourn this thing. It's now there's something else I wanted to show you guys just because I think it's kind of interesting. And this is because it's sort of a tactical question. Now I'm just trying to get these pictures copied over to my computer so that they will open better. But one of the questions people have is like, if you're in, if you ever find yourself in a gunfight or hiding from a gunfight, because you might not yourself have a gun, but you might be hiding from somebody who does, or taking cover. It's kind of a question of like, where do you, you know, what is good cover? And this is a question that people often ask about vehicles. And so I thought this was really kind of a cool opportunity, because how often do you get to see a vehicle that actually was used as cover in like an actual thing? Now I'm just trying to pull up the appropriate picture here. Where is it? Here we go. I'm going to close the other window because it's so. Is this gonna? Nope, that's not gonna come up right. Well, we're gonna redo this. I'm sorry, folks. I only do this professionally. This is the other side of the Humvee. And what I want you to notice here is that behind the engine block is no exit holes. And I just want to say here as well, the gun that was one of the guns that was being used there was a machine gun, a heavy machine gun, a 12-7 machine gun, which is the kind of machine gun you use for taking down something you really, really want to not see get back up again. The guy on the 12-7 was opening up on the engine block area, and there's no exit holes there. Now, there's these two guys who were in my way filming. These guys, I don't know. These guys are probably more famous than I am, so I'm going to be careful. They were filming a bit where they were laughing as they were filming each other and mocking each other's live streams. I don't understand. This is like a young people thing, but I can guarantee that they are more famous than I am. But the part I was trying to take the picture of is actually not these two guys. It was the guys behind them. And the guys behind them, you can see the Humvee, and you can see that part is riddled with exit holes. And so the behind part is not good cover. The forward part is excellent cover. And I see somebody saying they're taking very enthusiastic videos of one another's cell phone cases. They were doing a bit where they were each kind of mocking each other's live stream and mocking their own live stream, and I don't understand it at all. But I'm not required to understand it. That is not how the world works. I can just be an old person yelling at clouds, and that is okay too. I just want to note there were some other cool people there. Some of whom I got pictures of and some of whom I did not. So let's pull this one down and I'll show something cool. This is something that is really neat. Is this the one? Nope, that is the one I just showed you. This one. So this is a guy who I am just going to say the guy on the right, his screen name is something you're going to think is ridiculous, and he thinks it's ridiculous too. He started it as a joke. So the guy on the right goes by the name of Suckboy Tony. That's with an S, YouTube censors. Suckboy Tony. He thought that was funny before he became known, and now he's stuck with it. So, whoops. Choose your handles well, folks. That said, he is really cool. I quite enjoyed talking to the guy. And I'm also just going to note here, the thing he's holding is a pew-pew. It is a gun of a sort that I cannot describe on this stream because YouTube would be annoyed by it. It is a gun that was created through the process of a number between 2 and 4 dimensional deposition of material, because they don't want me to say the words. But yes, it is electrically fired. It is really cool. It is one of the coolest things I have seen out there. And so he's got it out there. I wasn't able to shoot it, but that may change in future. It is it's a really neat item. And he brought the prototypes there. He was showing them off, and it was really fascinating. I think that in a day where there was all sorts of like really neat firearms out there, there were, things like, grease guns and all sorts of things. That was the coolest gun that was out there. And that's the one I wanted to see and was really happy to be able to check out and to hold. So next to him is Brandon Herrera, the AK guy, who is doing a little interview with him right here. And so, yeah, that was pretty fascinating. I can show you guys a closer up view. I'm just trying to pull it up here. Let me just stop that screen, present a new screen. And YouTube, this is not, not automatic or anything like that. Nobody's handling it here. This is just a prototype in a box. There's no discussion of how to make it. There's no any of that. But yeah, I got to check that out and have a look at it. It was pretty darn cool. So there was a whole bunch of stuff I got to shoot. There was some stuff I didn't shoot, but I thought I'd play a little game with you guys. So I got pictures of a bunch of tables. And I know you're saying, oh, Runkle, you took pictures of tables. How freaking fascinating. Good for you. So let me show you some pictures of tables. Table. 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 Nobody's handling anything. Nobody's reloading. Nobody's anything. These are just tables. Just in case YouTube wants to get freaked out here. I think that this is the first table that actually has a picture of something that is legal in Canada. Like the entire gun is legal in Canada. So, yeah. There was all the things, and everything was illegal. At least would be illegal in Canada. In the US, it's entirely legal, and that was really, really cool. So, somebody says, don't let Kentucky ballistics near the tables. Do you know? I don't know if you're sort of aware of the story on that one. What is it? He had a what was the word they used with Elon Musk's thing? They said he had an unscheduled disassembly of a firearm. And that unscheduled disassembly was caused him to sustain a neck injury. So he managed to not die from his neck injury by sticking his thumb in it. And yeah, I saw the guy. I met Kentucky Ballistics, and he's got a gnarly neck scar. It I don't want one of those. So yeah. Whoops, there's a comment here saying I'm still shocked he made it through that. Me too. I mean, his survival on that one was nigh unto miraculous, is how I'd put it. So that's one of those ones where it's just like, all right, people got lucky. So you don't want to live your life in a way that luck is what's going on. But that one wasn't his fault. It wasn't that he was doing something unsafe. It wasn't that he was doing something doing something crazy or anything like that. Yeah. All right. So all right. So I'm just looking here. Now I see there's a whole bunch of things I am juggling. I wanted to talk a little bit. Oh, I see somebody saying, is Cheney still alive? It's not Cheney that you got to worry about. It's everyone who's downrange of Cheney. This, by the way, I've got two drinks with me. I've got one that's just straight Coca-Cola and one that is a dark and stormy. So, let me just see here. Trying to juggle some things right here. Let me pull up. There is a number of cases I wanted to cover. One of them is one that's been making everyone very sad, or mad, or both. And I'm just trying to find it here. Where did it end up? There we go. Just opening this document. Everything is sluggish today. Most especially me. I am travel always messes me up. And part of the reason why it messes me up is that one of the things I lose out on during travel is sleep. I don't know if you've ever tried to sleep on a plane. You can sleep, but you don't really get full proper sleep. And I am seeing people say swoop. Classic swoop. All right. So this was covered on Friday Night Frenzy, but we're going to cover it as well because I got some thoughts on this one, and I have some thoughts. So this is the Kowalski and Johns Hopkins All Children's Hospital. Second supplement to defendant's motion for new trial based on juror misconduct, etc., etc., etc. Basically, now I'm just trying to see here. Sorry, I'm just also trying to send some messages. So what happens now? This one is one that annoys me because it illustrates just how wrong the media gets it sometimes. And I see people saying there's a response filed this afternoon. I don't have that response yet. I would like to get a hold of that response. So we're just going to try to get that one. If I can get it, we'll go through it. But I kind of want to read that response if we can get it, but I don't have it right now. If somebody's got it, feel free to send it to me on Twitter, etc. Twitter, Discord, whatever you've got, and I will look through it. That said, this is the motion where they want to have a new trial based on alleged juror misconduct. Now, the news misreported this one dramatically, because the news articles, the news headlines said Johns Hopkins calls juror 1 a World War II German soldier. We'll go with, because we're still not into spicy time, and yeah. Oh, and Rob will send me the response. Excellent. Thank you, Rob. I really appreciate it. That is not what is correct, because they don't actually call him the N-word, the German N-word. We'll go with that. That seems appropriate, or inappropriate in fun ways. What this actually is that they say that juror 1 was biased. And their evidence for that is super, super thin. So this is a copy of the note, or they're relying on a copy of the note sent on or about October 12th, 2023, during the trial, and shortly after excerpts of Dr. Sally Smith's deposition testimony were published to the jury. So this is, let's look at the first thing that they're relying on, is Exhibit A. So Exhibit A, will the jury be able to observe Sally Smith? And you see those S's. Those S's are really critical here. As a live witness or by Zoom during these proceedings. And are we able to be told whether there's stuff about Sally Smith? Is Sally Smith still doing more performing duties at Johns Hopkins All Children's? So now what they're making a lot of hay about here is that the Sally Smith has these differently shaped S's than the ones that you see in, do I have, I don't really, do I have draw? Okay, draw tools. So like this S, they say is different than this S and then this S. And so that's why they've got these, that's why they're making some noise about this. They're saying these S's are special S's. Special S's. And they say this S and this S. As compared to this S, or yeah. So, or this S, which looks, I don't know what's going on with this S. This S was like half finished out of the factory. This S is, yeah. So, why do they say this is of significance? Well, that gets us to Exhibit B. Exhibit B is an excerpt from the website of the Simon Wiesenthal Center, documenting the experience of a uniform badge of the German N-word, German Schuhstoffel, or SS. So they say, it will be noted that in Exhibit A, juror number 1 has printed the letter S throughout the note normally with a curve in the spine, except that he printed his S's with sharp angles when printing Dr. Sally Smith's name. Both the second and third times that he prints the Sally Smith's name, it's shaped in a manner identical to the symbol of the Schuhstoffel. So, let's look at Exhibit B. And YouTube, this is from the Simon Wiesenthal Center. This is not intended to support this this ideology. Everyone involved in this agrees that this ideology is terrible. So they note, this is the that's the symbol, that double lightning bolt. Now, they note here, they say, extremists will sometimes use lightning bolt emojis to evade detection by moderation systems on social media platforms. let's just have a look here. So you see, and then there's, whatever else. Now, one thing I'm just going to note here is that in the actual symbol here, those lightning bolts are actually very distinctive and kind of tilted back, which is not the case over here, that they're tilted forward. And you see here, it's, this one seems to have some curve to it. And then this one, a little less curve to it. And then it's a little harder here and, later on. Now, I don't really know what these things are about, and I can guarantee you that they don't either. This is them grasping at straws. And I feel like if you want to, say this about a juror, you better bring some stronger arguments to this. Because this is really, this is weak. Now I'm just going to note some other things here. Those S's are actually a little more similar to, I don't know, these S's. Because if you see the lightning bolts here are almost perfectly vertical up and down. Whereas the kiss symbol is a little more slanted over, and his writing is even more slanted over. So it looks a little bit more like kiss. So maybe this juror is biased in favor of the band Kiss, which, not my cup of tea, but, they got some good songs, but I'm not that much of a fan. So yeah. Now, the one thing I think might have helped them as well is if they had a name of a number, of somebody else. Like they really need some additional, backup on this. This just seems like, let's throw some stuff against the wall and see what sticks. The other thing is that just, occurred to me on this one is juror number one, we know he's a cop, right? It came out that he's a cop or a former cop. And police officers tend to emphasize names in their writing. Why? Because that is part of their training. Now, I'm going to take a different stance from some of the other people on YouTube. I think that they will manage to dodge sanctions on this particular issue, if it's the only issue. Now, what I mean by that is I don't think it's okay. I just think that there's enough to throw this together, enough to say that there's an argument that they can argue, listen, we made this argument in good faith. I think that they're going to be able to spin that, notwithstanding the fact that we know where this argument comes from. This argument comes from Reddit. Somebody on Reddit came and got this. And this is some crazy conspiracy theory off people on Reddit. Now, I wouldn't have filed this. I would not have filed this. This is the kind of thing that when you file it, it tells you that the other side, that you have, it tells people involved that you have nothing. Because why would you file such garbage if you've got any actual argument? Now, I just want to say as well, that this, and they also have some things here about, in this other document, he draws his S's normally. His S's are still weird here. But like, what does this mean? I don't know. Maybe he was lazy. Maybe his hand was hurting. Maybe something. I don't know. But they like to jump from he drew his S's weird, so it must be that he's accusing, and they're not saying juror 1 is World War II Germany. They're saying he's accusing Sally Smith, or he's likening Sally Smith to being World War II Germany, i.e. that he's so biased against Sally Smith. He hates her so much that he's comparing to World War II Germany. I just want to note, when I look at this, I see that his S's are all over the place. This S is different than this S, which is different than this S. I mean, all of his S's are sloppy and weird. His handwriting is just, it is what it is. So, yeah. Now, I think we need to look at this in context, because this guy, I mean, they've now suggested this about him, and if this was all they did, I would say they are jerks, and they're grasping at straws and whatever else. But this is not all they've done. Not at all they've done. What else have they done? Well, they went ahead and doxed this juror, right? You remember that they went and, they say accidentally, but accidentally is just careless, right? Accidentally in this case is just careless. They published all of his information into the public, and then they accuse him of bias in a fashion that gets the news media to start suggesting. Now, I don't know if they can be responsible for the news media getting it wrong, right? I love this comment. Rob, I'm starring that. We're going to bring that up. Now that they've accused him like this and also published his home address, that is a little bit of a different animal, because that could have people a little upset. And speaking of drawing your S's and how you draw your S's, Rob here dropping some fire. The S I write on the sanctions order would be different too. Let's pull up this response, and I think I can guess that Rob's S would be sort of a normal shaped S, but with 2 vertical lines through it. I'm guessing that is the S he'd be drawing. Yeah. So now this I'm responding to. I hadn't seen this before. I've been busy at work all day. What is it? We're going to have a look at this one. Yes, people have got the S's correct on this one. And all the zeros. You're just going to be writing zeros until you get tired. So we're going to read this response and we're going to react to it live, because I have not seen this one before. Plaintiff Jack Kowalski's response to defendant Johns Hopkins post-trial motions. Plaintiff Jack Kowalski, individually and on behalf of MK, a minor. Now you might be saying, why are they still saying MK? Because I don't think there's many people in the chat who don't know who MK is at this point. It's not like Michael or, Marvin or anything like that. On behalf of MK, well, because they had a court order that said you've got to redact this, and even though there's been tremendous coverage, that's still the order, right? You still got to follow that. So, introduction: defendant's 144-page motion shows defendant still does not get it. Defendant now blames the court and the jury and continues to maintain there was nothing wrong with the way it treated Maya and her family. Defendant argues in its motion that any injuries suffered by the family were not so bad, were the family's own fault, and any harm visited on Maya, Beata, Kyle, and Jack was caused by the DCF because defendant was simply following DCF orders. As the manifest weight of the evidence demonstrated, Johns Hopkins All Children's Hospital, through its doctors, employees, and agents, each of whom defendant accepted responsibility and liability for, did the following. Now, accepted responsibility and liability for. There is important concepts that show up in law. One of those is that you are typically responsible for the actions of your employees within limits. And so, for example, the example I'll use is, let's say I start up a delivery company. Like, I've got my own courier company. We're going to compete with UPS. We're going to compete with FedEx. We're going to compete with all of those guys, right? And so, because we've got a courier company, we got guys driving around in vans. And one of those guys, and Rob, yes, I did. I'm getting to it. One of those guys drives over, somebody's kid, or, let's make it a little less dark. One of those vans drives over your lawn and wrecks your flower bed. Flower bed is less dark than like running over your kid. We'll go with that. So, and you say, hey, you drove over my flower bed. You're responsible. And I go, no, it's the driver's fault. And the reason why you're upset by that is that I've got the big company. I own the van. I own the stuff. I've got all the assets. Whereas the driver is some guy I hired and he's getting paid $8 an hour to drive, which is probably illegal, but that's a separate issue. You want to sue me because I got all the money. And so there's a concept called vicarious liability, which says that because he's my employee and he's acting in the context of his employment, anything he does is on me. Now, there's a limit to a vicarious liability, right? Let's say that same driver, instead of driving through your mailbox or driving through your flower bed or whatever, he pulls up in his car and he throws a Molotov cocktail at your house for no reason, like just because this guy is a crazy person. Well, that takes us outside of vicarious liability because that's not in the context of his employment. That's just he's a crazy person, and there's no way that I could that's not something I can control for, right? That's not, unless there's something where maybe I am responsible, like the guy said, hey, I'm going to firebomb someone's house, but assuming that isn't the case, or maybe he's off work and he does it, right? And it's like, how's this my fault? Like, this guy is doing this stuff on his own time. That's the limits, right? But if you're acting, if they're acting in the course of employment, there's typically vicarious liability. So that's what they're talking about there. Now, I'm wondering, we see this one and, Rob called this out and I was going to mention this. They say, because defendant was simply following DCF orders. If this is the same response that's going to cover the whole, the whole S's issue, then they're dropping some very subtle, very nice shade of their own back at Johns Hopkins, because that's the Nuremberg defense, folks. And I will tell you, the Nuremberg defense is so excellent at what it does that it gets you hanged. Don't use the Nuremberg defense. It is not a good one. So they did the following: negligently and almost instantaneously changed Maya's complex regional pain syndrome diagnosis over the weekend. Although her diagnosis had been confirmed by no less than 5 outside treating anesthesiologists and neurologists, and recognized by the defendant's hospital on each and every of Maya's approximately 20 previous visits and admissions, kept Maya in the hospital without legal authority, and despite her parents' repeated requests for discharge, refused to transfer her unless they signed off on the suggested diagnosis of Munchausen's by proxy, and admitted that Beata had a psychiatric condition that led her to physically and emotionally abuse her daughter. why would anybody ever sign that, right? Covertly videotape Maya to try to prove she was participating in a charade to assist and cover for her mother, who had fabricated Maya's CRPS, and in doing so, placed the commode out of reach that Maya would be forced to get out of her hospital bed when she thought no one was watching. Instead, she defecated on herself and was dragged to the commode by hospital employees. And Johns Hopkins is wondering why they had to write the big check on this one, or why they are going to have to. Like, why would the jury be angry about this? Keeping in mind that Maya was really, really young. Like, she's a really small child. Assigned Catherine Beatty, an employee with at least 3 documented disciplinary and anger management issues, to be the primary overseer of Maya. Nurse Ratchet was apparently busy, so this was the best they could do. Allowed Beatty to repeatedly engage in unwanted contact with Maya, including hugging, kissing, patting Maya's legs, and placing Maya in her lap. There's a term for that, and the jury awarded a bunch of money for it. Forced Maya to endure physical therapy without pain medications, and enticed Maya to push beyond her limits by enticing her with the promise of chocolate cake and going to church outside of the hospital, only to be told by Beatty that she'd not tried hard enough and would not get chocolate cake or to go to the outside church. I'm just going to say, like, people tend to ask lawyers, and especially criminal defense lawyers, there's always somebody who asks, like, how can you defend guilty people? And, like, well, they don't typically ask that of, like, people who represent a hospital or of Beatty, but yeah, yeah, withholding somebody's access to church. I mean, I'm just gonna say I am not a religious person. Like, I think I've mentioned that on streams before, but I would not do this. Like, somebody's access to church is pretty, if you pardon the word, sacrosanct. You don't do that. Like, just not cool. Are you telling me the cake is a lie? Yes, the cake is a lie. Fun fact. So, when my wife and I were planning our wedding, Rob, take notes. She was like, I want to choose the first dance song. And I said, okay, deal. But I get to choose the cake cutting song. And she said, all right. And she was suspicious because she's like, why would Ian be cool, or why would he be going after that? And so the cake cutting song at my wedding was "This Was a Triumph," making a note complete success. So I picked Still Alive by and so I will say that the people who were attending the wedding had a mixture of reactions. Some people were like, what the hell? And some people thought it was absolutely hilarious. But yeah, that was our cake cutting song. My wife did know, like, the meaning of it. She's like, you know what? I'm going to let you have your fun. This is fine. So somebody saying what song, I'd play the song, except I would get a copyright strike. So look it up yourself. It's Still Alive is the song. If you put in Still Alive Portal, you will you'll get that. Rob says, my cake cutting song, I came in like a wrecking ball. Cake will splatter the walls. I have one level of effort. Fair. If you play the first Portal game, you will understand why that cake cutting song is hilarious, or at least why I think it's hilarious. There's a difference between what I think is hilarious and actual hilarious sometimes, But yeah. Routinely interfered with Beata's visitation rights, allowing Beatty to sit in, interrupt, and disparage Beata by making inappropriate faces, rolling her eyes, and otherwise acting like a toddler while Maya was on the phone with her mother. Required Maya to keep her hospital room door open while having what should have been private conversations with her attorneys, Michael Kelly and Mark Zimmerman, and rationalizing this infliction of emotional distress with the implausible excuse that the hospital staff had to keep the door open for fear of Maya falling and being left on the floor by her attorneys. This is insane. I can tell you, if I'm representing a child and the child has an I've fallen and I can't get up moment, I am not being like, whatevs. No, I'm calling for help or I'm getting them up off the ground, whatever. Provided less than 5 hours of cognitive behavioral therapy, even though that was one of the pillars of therapy for her treatment. Forbade her from engaging in religious practice despite the hospital's own patient bill of rights and in the absence of any dependency court order authorizing such a prohibition, including removing her religious artifacts from her room, instructing Maya's priest from her family church that he could visit but not pray with Maya, and kicking out members of Maya's church who visited as part of the Legion of Mary with the good faith intent to leave Maya with a statue of Mary to watch over and comfort Maya. And I seem to recall that they also threw out the Eucharist. And the Eucharist is one of those things that has rules about it. Now, I'm not Catholic, but I know that you don't throw the Eucharist into the garbage. That's not cool. In the same way that you don't throw a Quran into the garbage, you don't throw the American flag into the garbage, all sorts of things that, people, when people venerate stuff, you treat the stuff with respect. Yeah. Habitually lied to Maya, telling her that her illness was all in her head, her mother was in a mental institution, and Beatty would be her mother now. I watched this trial, and every time I read this all, it just makes me angry again. Because I'm just like, I'd forgotten about that. And that is so messed up. They suggested that Jack consider divorcing Beata. Chat. This is a heavily Catholic family. Can you tell me, how does Catholicism view divorce? Is that something you can do like recreationally in Catholicism? I'm seeing no. I'm seeing that Catholicism does not allow that. Okay. Forbade Maya from having contact and social interaction with other children on her floor, and further dehumanized Maya by not even placing her name on the door of her various hospital rooms. The not placing her name on the door, I'm like, I don't know. But not having any contact and social interaction with other children on her floor is messed up. Like, you want a kids to still socialize so they don't get weird. Refused to deliver gifts that Beata and Jack brought to the hospital for Maya, including a birthday card to commemorate her 11th birthday and a white Christmas dress, one of her favorites sent by Beata, both meant to remind her how much she was loved since she was forced to celebrate these occasions alone in the hospital, which is also messed up. So not too long ago, I went to the hospital for appendix surgery. And appendix surgery is, it's either not a big deal or it's a really big deal. And mine was in the not a huge big deal category. And what I mean by not a huge big deal, I mean, surgery is always kind of a big deal. Like, some weirdo with a knife is going to start hacking you open. Like, that is, that's a thing. By the way, my brother's a doctor. So when I say some weirdo with a knife is going to be hacking you open, I'm kind of, but, and they gave me the option, like I could have antibiotics or I could have the surgery. And I was like, what do you recommend? They said, we recommend surgery. And I said, do it. So, anyway, they they knocked me out. They hacked me open. They cut out my appendix. My appendix had not exploded. And so therefore I was, it was a fairly quick in and out. I stayed there, like after I woke up, I stayed there about another 8 hours before they said, okay, you're good to go. Out you go. During that 8 hours, I had visits from my wife and a friend of mine. Both of them stopped in and visited me. The notion that she can't visit like her family members, whereas I got visits when I was just there for like a little bit for a fairly routine surgery that went just perfectly well. That makes me angry. And hey, Megan, I see Megan Fox in the chat saying, glad you're going over this, Ian. Yeah, this case makes me angry, and it should, because it's messed up. So refused FaceTime calls between Maya and Beata in the last 10 days of Beata's life, despite the order that they facilitate these FaceTime calls. So they refused to follow a court order. Stripped and photographed Maya over her objections and tears without her parents' consent, and under Beatty's threats that if she did not allow the photos to be taken, she would not be allowed to attend the dependency court hearing later that morning. I mean, I'm just going to say they're really kind of lucky. I mean, I don't want to glorify anything, but like Beata took steps that were extreme in order to try to help her daughter. And ultimately, that ended up. But I'm just thinking, like, all of this stuff, if you asked me, make a movie about how this goes, this movie would be like another Rambo movie. It'd be like the First Blood movie, where it's just like, okay, here's John Q. Rambo, and he's just, like, he's going to raid this hospital and rescue his daughter or something. Like, this is, and don't do that, folks. That's a bad idea. I'm not recommending anything. I'm just saying this is so messed up that if you told me all of these things and I hadn't watched the trial, like if I hadn't watched the trial and you just told me that this is what a hospital did, I would be saying, no, like this is so unbelievable. This is so beyond the pale of what you would expect anything to be happening here. So, but here we go. Conducted a relentless intimidation and harassment campaign against Beata, beginning with the refusal to honor Beata's request for Maya's discharge in the first week, with knowledge that the hospital's actions were driving Beata towards unaliving and abhorrently predicting Beata's final act. Having now reminded defendant of the outrageous conduct it refuses to address. See, this is where you want to be as a lawyer. And because they get to be in the catbird seat here. They get to be in the seat where you get to just clothe yourself in complete righteous authority and just drop bombs on the other side. Having now reminded defendant of the outrageous conduct it refuses to address, let me remind you that you are dirtbags. Now we're going to keep on and go from here. Whew. None of which was compelled by DCF. So that, they get to say, hey, you say you were following court orders. Look at all the times when you were doing this in violation of court orders. You say you were just following orders. You were not just following orders. You were, in fact, going above and beyond the orders. And so you get to own that. So, Plaintiff will respond directly to defendant's motion. To make this response more manageable, yeah, there's a lot of pages to this one. I don't know if we'll get through all of them, but maybe, because I'm mad, and this is, yeah. Plaintiff will follow the format and organization used in defendant's motion. Plaintiff does not, of course, agree there were errors, etc., as alleged in the defense headings, but to respond initially to some themes in those motions, plaintiff offers the following. As defendant acknowledged during the trial, this case is unlike any other. Thus, comparison to torts and verdicts in other cases, such as where a plaintiff died after a lifetime of choosing to smoke, are of very limited value. I.e., you've cited some precedents about like past, dollar amounts. You dumb. Those don't work. Contrary to defendant's sky is falling claim that if this verdict stands, no facilities will agree to shelter children, the result here will mean that no facilities will treat a child and her family as defendant treated the Kowalskis. And I think this is exactly the point, right? Like, if I invited a homeless person to stay with me off the street and then, chased after them with a rake and hit them several times with the rake, a finding that I did wrong by chasing after them with a rake is not going to say that people can't do nice things to the homeless. It's going to say you can't hit them with a rake. And please, chat, do not hit the homeless with a rake. That is not a cool thing to do. The Florida Supreme Court long ago rejected the logic adopted by the defendant here that ACH, Johns Hopkins, should be given blanket protection by Chapter 39's immunity provision, even though they violated and abandoned its duty of care to Maya. And this is in a prior case, Department of Health and Rehab Services versus Yamuni. In a variation of the duty argument above, HRS also argues that even if it violated its duty of care, they are immunized from liability. We do not agree. To so read Section 827.07 sub 7 would turn Chapter 827 on its head by protecting the legal protector from the protected class. Section 827 protects against liability for carrying out the protective measures on behalf of the protective class. It does not protect against failing to carry out the protective measures. So, HRS is the predecessor to DCF, but the same logic holds true whether DCF, a sheltering institution, or a foster family who find themselves entrusted with the care of children via an intervention by DCF have a duty of care. Person taken into custody is owed a common law duty of care, i.e., if you're, if you're arrested, if you're taken into a mental hospital, anything like that, they have to care for you, because once they take you in, they got to care for you. Makes sense. All right. Johns Hopkins is no different. Having been entrusted with her care during her sheltering, they owed her reasonable care. Guys, this should not be something that needs to be said, but it needs to be said. They abjectly failed to care for Maya, instead placing her in harm's way of its agent, Dr. Sally Smith, to provide the charade, and Beatty to carry out her perverted motives. That's a double entendre here. That's a pretty ugly double entendre. I mean, ugly. I'm not criticizing the lawyers here. I'm saying it's ugly because of the circumstances, right? I'm saying that it's ugly because normally I would say that like this indicates that somebody's motives are bad motives. But given that they found that what BD did was an SA, whew. All right. Plaintiff repeatedly put defendant on notice of the harm being visited on them, as demonstrated by the risk management records and letter addressed to Dr. Jennifer Katzenstein, complaining of BD's inappropriate conduct. Yet, despite the actual knowledge and foreseeability, defendant took no action. Now, I see somebody saying they chose those words for a reason. I am just going to say the lawyers on Maya's side seem to me, I've never met them. I haven't actually had a direct conversation with them, but I will say they seem to me to be very smart people. And it seems to me that they don't do a whole lot by accident. I could believe that they chose that very carefully, because they got some snark on them. They know how to turn a phrase. So, no child had ever been sheltered in their hospital for as long as Maya, over 3 months. Because her situation was unprecedented, the defendant's dire prediction of the negative impact this verdict will have on other sheltering facilities is unwarranted. I.e., there's never been a case like this before, so you can't say this is going to cover every case. Upholding the jury's verdict, however, confirms that the sacred duty to care for children also extends to sheltering institutions, including children's hospitals. Good. Chapter 39 immunity. This court carefully carved out the actions that were not subject to Chapter 39. Plaintiff moved before trial to take Chapter 39 out of the jury's consideration altogether by the court preventing any mention of the DCF proceedings. Defendant successfully opposed that motion because it wanted the jury, not just the court, to know about Chapter 39 immunity. Defendant now regrets its strategic decision, claiming that Chapter 39 immunity was used as a sword and not a shield. This is a very common thing you will find in the law. Let's say at trial, they ask my client a question that is objectionable, right? And let's say I don't object to it. Well, sometimes there's a reason for it. There was a case that I had where my client was being asked all manner of questions, and some of those questions were questions that are objectionable, that were improper, totally objectionable, and yes. So I was like, I'm going to let this one roll. I just didn't object because I wanted to see my client answer it. My client was doing such a great job on the stand. I wanted to let him answer it. And the judge looked over at me like, you going to let this happen? And I gave the judge a little nod like, yep, letting it ride. I know I'm taking my risk here. And my client nailed the question, just blew it out of the park. The prosecutor regretted the question. And I'm being very vague here because I don't want to reveal who my client was or anything like that. I can't do that, of course. But my client nailed the question. The question was essentially something like, you broke the law on this past occasion. Why wouldn't you break the law on this current occasion? And that's objectionable. That's not a proper question. But my client just hammered that by giving a really good explanation. He just nailed that explanation. And so at the end of it, the prosecutor was like, eh. But the thing is that if I went and said afterwards, listen, I want to appeal this after I lost because we didn't object to this, the appeals court would quite properly say, you do not get to appeal on the basis of your own tactical decisions, right? You don't, if you made a tactical call, you don't get to use that to appeal. So what they're doing here is they're saying this was a tactical call that they made. They got to eat that. And Rob here saying, my favorite litigation move of all time is to try to anticipate the mic drop that counsel wants so bad and let them ask it. Only to drop my own mic in 2 minutes. Ain't nothing better. Gold. Yep. You just annihilate that. So, yeah. Defendant should be glad the jury did not hear the full extent of its and counsel's active role in prosecuting the DCF proceedings and urging the dependency court to implement the constraints and restrictions on the family's visitation rights that defendant attempted to hide behind during the trial. This is weird. Because there's the dependency court. Why is the hospital acting in order to limit, like, to take a role in this? Normally, the hospital would just be like, listen, not my circus, not my monkeys, not my clowns, not my bear riding a unicycle. None of this is my problem. You guys sort this out in dependency court. Tell us what you've decided, and then we'll do that, right? Like, whatever you guys decide, we'll do it. But you guys decide it without and this time they were like, send in the clowns. And they got in there. Why would they do that? Do you think the jury would have had opinions on that? Yeah. And defendant should be glad the jury did not hear the full extent of its and its counsel's active role. This is a really interesting turn of phrase, and I have finished my Dark and Stormy. But this calls for some scotch. Defendant and its counsel's active role. Now, there's a little bit of a legal fiction that we use in law. And legal fictions are basically things that are not true, but we pretend they are for the purpose of court. And the legal fiction is that all submissions come from the party, right? So, in a recent case I covered this case a little bit ago here. It's up on a video there, where you say, like, where the lawyers behaved badly by comparing a witness to Charles Manson. And so it was like defendant submits, or in that case it was the plaintiff. Plaintiff submits that counsel should not have to pay the costs personally. And I'm like, I don't think that that's actually what plaintiff would want out of this one, because plaintiff, otherwise she's got to pay it. But they, like, the statement from the lawyer is taken as a statement from the person. When they, in their filings here, start to say defendant and its counsel, and start to split them up like that, and say both of these people, now we're talking about some suggestion that the lawyers behaved badly, and that the lawyers themselves should be on notice. And this is the kind of thing you don't want the other side to be saying about you. So let's have a little sip of scotch and move on. Negligent training. Defendant repeatedly asserts that the negligent training claim should have been directed out sooner and is another source of its problems. Florida law requires hospitals to have competent staff, and hopefully not evil staff. Proper training and supervision is part of that mandate. Plaintiff offered to make that a part of the medical malpractice claim, but defendant refused. Without trying to assess blame, no agreement was reached. Without trying to assess blame, it's their fault. But this is all irrelevant because defendant ultimately acknowledged that negligent training was relevant to the punitive damage claims. And then they're going to quote Mr. Altenburn. There may be some element of this negligent training that relates to a punitive damages claim. So I always kind of listen to this with the same interest that you had, but I'm not sure how it ties into punitive as compared to training. But I'm not going to tell you that I'm 100% convinced that there's not, as you've used the word, scintilla of evidence that this somehow relates to punitive damages. I'm essentially conceding to you that there's a level of this that can be talked about for punitive damages. Concessions are a really big deal in the law. You don't concede something if you don't mean it, because once you concede something, it is considered a fact, like it's considered absolutely true, or if it's a legal argument, you have essentially abandoned that legal argument unless it is so egregious. Like, you can't concede that like up is down, legally speaking. But if you concede that your client is at fault for something, then your client is conceding, or then your client has agreed that that is the truth, right? And if you concede a legal argument, so long as that legal argument is reasonable, like it's not, you can't, like, the prosecution couldn't concede that murder is legal, for instance, but they could concede that your client acted in self-defense, and then they're done. They can't argue that later, right? So they hasn't pointed to anywhere that it requested an instruction limiting the training evidence, so they failed to object. They acknowledged that keeping Catherine Beatty assigned to Maya's care was a negligent act of supervision or training, because she crazy, because she horrible. As discussed below, hospitals are legally responsible for adequate training and supervision, whether the actor is inside or outside the scope of employment. So, specific intent. Whether the defendant had the specific intent to harm Maya for purposes of the punitive damages instruction or limitations of 768 was properly on the verdict form for the second phase of the bifurcated proceeding as per the standard jury instructions. Putting the specific intent question on the verdict form in the first phase would have introduced an issue as to the amount of punitive damages before a jury finding that punitive damages were recoverable. You put in the cart before the horse, and that's not the way horse and cart goes. Horse first, then cart. Defendant also has shown no harm from this because it is not argued, nor could it, that the amount of punitive damages awarded exceeded the maximum amount awardable under 768. So this is something about like busting the cap, and they didn't bust the cap, so you can't argue that you were damaged by the cap busting. And I mean the punitive damages cap, not like pew pew. So yeah. Defendant had the opportunity to present evidence on this specific intent issue in the second phase of the bifurcated proceedings. Despite the court's repeated admonitions that the punitive damages phase would follow directly and immediately after the jury returned its verdict, if it found in plaintiff's favor, defendant apparently failed to prepare its evidence to rebut plaintiff's punitive damages evidence, and as a result, failed to present its evidence at that time. When the court says, listen, be ready, we are proceeding with something right after this other thing, you got to be ready to do that thing, right? Like, that should be pretty basic. I had a trial where the judge basically said, and the judge said this at the outset, so it was not like right at the end. There would have been an issue if they'd said it right at the end, but the judge said, listen, we're going to be on short time frame. I don't know whether I'm going to end up acquitting or convicting, but I want both sides. And this was like a 3-day trial. The judge said, I want both sides to be ready to present at least initial argument about sentencing right after the trial. So I did all my sentencing prep, and then my jerk client got acquitted because some jerk lawyer did a good job, and we didn't end up needing it. But if either of the defense or the prosecution had said, not ready for sentencing, the court would be like, listen, I told you got to be ready. So go. Rob makes an excellent point in the chat saying the hospital has tremendous resources. It's not like they could say, we just weren't able to get all of this together in time, because they got hojillions of dollars. Like, they got lawyers out the wazoo. Get it done. The delay beyond November 9th defendant requested was not reasonable, and apparently was dictated by the vacation plans of one defense team member for the week beginning November 13th, as discussed next. This is not... I mean, I'm just going to say, you book you book vacation time after a major trial like this. I get that. But you leave some leeway to get your work done. You just gotta do that. Defendant's argument, it was harmed by the court's decision to place both options for the burden of proof on the specific intent issue on the verdict form, is speculation at best, with the jury not needing to reach the lower standard alternative question. As was done with other items, the verdict was structured to avoid having to retry the case. This was very interesting, something very interesting by the judge. So there was argument as to the standard of proof on this one. And the standard of proof, like what level of proof the court had to read, or the jury had to reach. And so the court basically said, I'm not going to decide on which standard it is right now, because either way I decide, one of you is going to be arguing this on appeal. So instead, I'm going to give the jury both standards, and the jury can tell us whether they've met both, only one, or neither at all, at all. And then if this does go to appeal, then great. The Court of Appeal has it. And the reason why Johns Hopkins did not want that is because they were worried that exactly what happened in this case would happen, which is that the jury would say, listen, we find on the stricter standard. At which point, if they go back and they say, hey, we want to appeal based on, all right, the jury already found that we would be liable on the standard that is most in our favor. Whoops. Time. Defendant's insinuation that it was harmed because the court did not give it adequate time to present its case was never raised during trial, which is when you got to raise it, nor did defendant use all its allotted time or make a request for additional time that the court refused. If you want to say you didn't have enough time, run out your clock. And then ask for, say, hey, I want to just note that we would have used additional time. Court, we need another 3 hours. We've used every second we've got, or we're going to end up using every second we've got. We need another 3 hours, 6 hours, 60 hours, whatever it is. You got to ask the court for the thing and have the court say no before you can argue that decision of no was not appropriate. The court did not make a definitive pronouncement that the trial could not continue into the week after November 9th. In fact, the court alerted the jury during jury selection that the trial may extend into the week following November 9th. This is great, by the way, for plaintiffs here, because it's listen, the judge could have, he contemplated maybe that people would need an exception or an extension. Also, it was defense counsel who expressed reservations about extending the trial due to defense counsel's planned vacation for the week beginning November 13th. So you didn't want to extend it, they say, because you were going on vacation. I'm just going to say, if you become a lawyer and you start doing these kinds of, these kinds of huge, big trials, one of the things you're going to want to do is you're going to want to start booking your vacations, your holidays, with refundable everything. Sure, it costs you a little extra, but if you suddenly can't, if suddenly your $1 million trial, and it's like $1 million trial, many, 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 many times over. If suddenly that trial needs to run long, you rebook your stuff, right? And here's the other thing is that you could ask and say, hey, we would like to extend this. We've got a vacation. Can we, skip a week and then come back? I mean, the court would have said, are you kidding me? Yeah. The other side, or the other thing, is that I'm sure Johns Hopkins is spending hojillions of dollars on this. Hojillions. They've spent more money on this trial than I have made in my entire life. All in, over my entire life, I have not made the kind of money that it took for them to to run this, right? So, what happens if you go to Johns Hopkins and you say, listen, something's come up. I have spent $10,000 on a vacation. I need to cancel that vacation in order to keep running your trial. We're going to bill you the 10 grand for the lost vacation. Okay. I think Johns Hopkins would be like, let me sign the freaking check. And the other thing is they got lots of lawyers on this one. And this was like, when you've got a lawyer panel that deep, get one of the substitute, like one of the backup lawyers to do it. It's so damages, including non-duplication instruction and allocation among torts. I think this is where they might have an argument, where they might have a place for this. And because I'm not sure that the jury didn't think that they were including punitives at the time that they awarded compensatory damages. I think that they may have included the FU money in with the compensatory money. And then when it came time, and then when they were told, oh yeah, now you also need to do punitives, that they were like, oh, I thought we already did that. Have some more money. Like, I guess I'll get the shovel and give you another scoop. I think there's an argument here. So, yeah. The jury was instructed, although these claims are separate claims, it is possible that separate claims may result in overlapping damages. Your verdict should not award damages twice for the same loss, injury, or damage, even if they result from different claims. Your award of monetary damages for each claim, if any, must not duplicate the same damages awarded in the other claims. How do I put this? If there's two instances where where somebody hit your leg with an axe, and either of those instances would have been enough for you to lose the leg, you don't get paid for two legs because you only are missing one leg. You get paid for one leg once. You don't. That's not how that goes. So, defendant did not object to plaintiff's closing, suggesting the jury allocate the damages floating from multiple acts by the same tortfeasor among the torts in the jury's discretion, which, of course, is what you would have wanted to do if you wanted to have an issue with it, is you object to it. Allocating among claims is consistent with the multiple events instruction when there are multiple tortfeasors. Tortfeasors is wrongdoers. Plaintiff had proposed a much simpler verdict form that did not allocate damages among the different claims, which defendant rejected. So you guys asked for this. Come on. Plaintiff presented a logical option for the jury to evaluate damages for Maya's physical and all family members' emotional pain. The jury heard testimony that Maya's CRPS is the most painful neurological condition from which a person can suffer. Ouch. And defendants tried to rebut this by showing that she was, that, she went to prom or went to homecoming rather. Yeah. F those guys, by the way, with a shovel, with a shovel. So yeah. And not like just a regular shovel, but like one of the combat shovels that's got like the serrated edges. Yeah. All right. The jury paid rapt attention to both sides, was respectful to counsel, took copious notes, and asked thoughtful and penetrating questions of both sides. The court religiously reminded the jurors of their duties, and they consistently reaffirmed that they were following them. This court observed that this jury did its job. All right. Juror number one. Key theme of the motion is that the jury was under the leadership of juror number one and the verdict, therefore, was tainted. This is pure conjecture, as discussed in the plaintiff's response to defendant's motion for new trial. Defendant has offered no facts whatsoever in its motion that shows that any juror acted under the leadership of other jurors. I don't know how they get to leadership, right? Moreover, a verdict is not subject to attack based on matters that inhere in the verdict, i.e., those that arise during the deliberation process. Whether the other jurors viewed juror number one as a leader would be just such a matter. So, yeah. Yep, somebody's trying to call me. And, nope, they are not going to, what is it? They are not going to, we're not going to answer that one right now. I mean, I'm on a live stream, but also, nope. And if it was you calling me, don't call me during a live stream if you're watching this, because, like, no. I don't think it was, but so the jury is directed to accept a leader in the form of a foreperson as its first act during deliberations. Jurors' ability to understand the case. Okay, I haven't even read this one yet because this is like absolutely new to me. So before we read it, I'm covering my eyes. I can't read it right now. If the juror doesn't understand the case, what this is an argument of bad lawyering. This is an argument that you suck as a lawyer because your job as a lawyer is to explain to the jury the case. Like, that is a critical part of your job. And so it's like, this is like your mechanic saying, hey, I was trying to fix the car and that stupid car wouldn't fix itself. It's like, well, yeah, that's your job. You fix the car. You have to explain your case to the jury. that is the job. Literally, that is the job. So, oh my God. Also, everyone who's speculated as to who's calling, you're all wrong. It's none of that. All right. So, it's a family member. It's all good. Respectfully, that is nonsense. Simply because defendant was unable to persuade the jury it did nothing wrong does not mean the case was too complex to be understandable or that the jury was confused. This is a mistake lawyers make all the time. They get so enraptured with the righteousness of their case that they're like, well, if the judge didn't agree, or if the jury didn't agree, it's because the stupid judge or the stupid jury didn't get it. And often what you see is, in fact, they got it just fine. I've read so many cases where it's like somebody's like, oh yeah, this judge didn't get it. And I'm like, they understood. They just thought your argument was dumb. Traveling Science Man says, I bet Zora was calling. Zora doesn't call. She just makes her opinions known by eating an Ethernet cable. That is how she communicates. Also by nibbling faces. So now I'm just going to note we are 14 pages in and we have just hit the table of contents. Ooh, okay. We're not going to go through all of this today because, oh my God, this is going to be long if we go through all of this. But come on. I want to get now. Does this respond to? I got to see if this responds to the. Do we have the? No, we don't. We don't have the. I want to see the juror number one thing. Where is there no juror number 1 here? I gotta see if it's in here, because it doesn't appear to be in here. That is sad, because I wanted to really see how they respond to the critical issue of that makes me so angry. And so I'm just gonna see. Now there's another document here. I just want to see if this is related to it. All right. It doesn't look like we have a response at this stage to juror number 1 allegations. I see people saying it's there. Okay, let me try to find it. Control F. Nope, that's not there. Guess we'll. I'm just trying to find juror 1, number 1. All right. So there's that. There doesn't appear to be anything about the lightning bolt in here. At least I can't see it. So maybe if we just go down all the way, I suspect that might be coming in a future filing. Rob, you've read this, I think. Is it in here? Is there a juror number 1 lightning bolt response in this one? Because yeah, I want to read that. I want to read that so bad, because oh my god. So yeah. I see people saying the lightning bolt is not worthy of a response. It's not worthy of a response. They're going to respond to it. You do not. This is not a case. This is not a situation where you just leave something like that. There is the old adage of never interrupt your opponent when they're making a mistake. But some things you gotta dunk on. And I think some things you gotta respond to. I would respond to this one. I would respond to this one so hard. Yeah. So, and I have got a thing to share from somebody you guys know, a certain Robert, who has crafted some wonderful implements of destruction. So, well, not of destruction. I mean, they could be. So, we're going to share this. This is a couple of pens that were crafted. So the one on the right looks like it's an epoxy. That looks lovely. And you'll notice that the one on the right, that purple black kind of color, it's got some interesting fixtures to it. We're gonna zoom right in on this. We got a little pirate skull and crossbones. We've got a cutlass. It's a pirate pen. I got some ideas as to where that's going. I don't know if Rob's going to let me say where that's going, but it's clearly a pirate pen. Now, the one on the left, this is a really interesting wood where you've got these little speckles of color. That's got to be something that's got like thorns or little branches on it, maybe. That is a cool pen. I see somebody saying it's cholla or hollow wood. So people are telling me Rob has already noted that the one on the right is for Pixie. So these are both really nice pens. Rob does really good work. So that is, yeah, I haven't been able to make it into the shop right now. or for a bit. So I haven't yet managed to make it into, or I see people saying choya wood. Okay. I haven't yet managed to make it into the leatherworking shop since the charity stream. And I kind of missed that. So yeah. All right, before I get too annoyed, let us talk a little bit about let's go to something a little more fun. And I say a little more fun, but let's talk about some sovereign citizens, because we've got some sov sits, and sov sit's been sov sitting. So we're going to look at that. Oh, I'm also being reminded that I should cover some super chats before we get too far out. Let's do some super chats. Dog swoop. And for old time's sake, thirst swoop. I had to play it again because I know Rob's in the chat now. All right, so let's read some super chats and then we'll cover some sov-sittery, because yeah, Rob is going to be like, Runkle. Somebody says, why does the audio pan in that one? It's just what was in the original audio. It just is what it is. So all right. All right. So Rhineman YYC says, hey, from YYC, which is Calgary, better than YEG. I was in Calgary for an hour or so. There was not a single outlet to be found. So the airport's got to get on their game there. Somebody says I negated the wholesomeness of the puppers with that. So more wholesomeness just to restore the wholesomeness. Traveling Science Man saying, can we get the clown swoop? No. I'm not going to roll the clown swoop at this point. So Rob says, I hate you, lol. You don't, though. It's all right. We've got Rhineman YYC. Thank you for 5 gifted memberships. Sardanisms. Thank you for the membership there. Vez from Quebec. Good Monday night, all. I'll be on replay tonight. Have a good night, Vez. It's good. Always good seeing you in the chat. Cookie Mon Steve. Everyone makes mistakes is definitely worthwhile. That's referring to my hot sauce. Betty Ross saying, did I hear a rumor that there'll be Lawyers and Dragons this weekend? There will. That's the plan. Cherry C. Mills, thank you for the member anniversary there. 10 months. Awesome. Hi, Ian. Thoughts on breathalyzer check stops? The Supreme Court said that they are illegal. I wish they hadn't. It is what it is. I mean, at the end of the day, they're like, how else do they find drunk drivers? And I'm like, well, I don't like getting stopped and so forth. Rob says, go buy Ian's shirt. Proceeds go to my honeymoon. Lol. Yep. We'll Rob's honeymoon funded by the thirst. That's now I suspect we're not going to be able to fund a full honeymoon off of it, but everything counts. So I'm voting for you in both categories every day. Excellent. That is what we need. And Gwendolyn SS, which clearly can't refer to like her name. That's got to be. We're not going to go with Johns Hopkins here. They're just being silly. Casey Cat, Runkle of the Bailey. There's a new case like the Kowalskis in Georgia, the Hernandez family. Megan Fox covered today, and they all need all of our help. Dad to be arrested tonight, tomorrow. Mom on bond already. Whoa. Megan Fox, I'm sure, is going to dig in on that one. I will have to look into it. So I'll be playing catch up on that, but check out, so yep. And I see Canonical Heat. Thank you so much for the 20 gifted memberships. Much appreciated. Fiona W, thank you for 10 gifted memberships. Kristen M96, you can get the design on other objects like wooden wall art or a tape measure. Someone needs to send Rob the tape measure. I think this needs to happen. So, Lindsay, if you scroll all the way to the bottom of the Zazzle store, you can transfer it to other products. Mugs, golf balls, baby blankets, wrapping paper. Oh, I know somebody who likes golf. We got to send this to Rob on golf balls as well. Steve A, Rob can only ban that on his channel, not your own. I mean, he can ask. Start with the Burlew lawsuit. I don't have the link to that one. Kurt Easton, could you send me that? Because I would love to check that out. Greenwood Fire Response said, hey, Runkle, I have a question regarding law in your state. And that question was, so referring to your video about a certain proclaimed gun expert that had been with the ATF and a blunderbuss only being able to be used for hunting certain parts of the season. It's not that it's only able to be used for certain parts of the season, but there is like a primitive weapons season. And what that is that there's actually like an early season. So you can go hunting before anyone else and before the animals have really clued in that, hey, it's hunting season. Maybe you want to stay inside. So it lets you get an early head start, but you have to be using like black powder firearms and so forth. So, yeah. All right. So, what is it? Let's have a look here. Against the Tide, make sure to like and vote. Yes, thank you. Loretta, I miss those days. What are you making? Somebody was making something and I tagged it and I don't remember what it was. Sorry. Ruby De La Rosa became a YouTube member. Awesome. Thank you so much. Law and Lumber listening in, feeling like garbage, but glad to be listening. I'll send you the response on Signal. Thank you so much. I will, if I could, I would send Rob my chicken soup. My chicken soup is, right now pretty, it's both salty and spicy. So, yeah. It's good stuff. It's, I tend to make a chicken soup for like when I'm sick and it will, it'll clear you out. It'll get your sinuses moving because my, my preferred sickness soup is a chicken soup that will, that basically is like throwing a hand grenade to clear out your pipes. So, juror number 1 is living rent free in their heads. Oh my God. These guys are going to be just thinking about juror number 1 for the rest of time. What's the evil equivalent of a Hail Mary? You know what? I'm not going to say it because somebody's going to clip me saying hail something evil. And then they're going to clip that and that'll be like something. So, fill in your own blanks on that one. You could do your own Mad Libs on that one because it'll get clipped. I'm onto your game. Not you specifically, Ian, but just internet. I'm onto your game. At what point do they hit defamation of juror 1? It's really, really hard, and I don't think they're there yet. I don't think that they're there at all. So the court, please place your motion in this Pringles can. Oh. It's to distract from the IG Discovery shenanigans. I think the court should be hammering them on those Discovery shenanigans so hard. So hard. We'll see how that comes. Morgan spent a long, painful, lonely couple of weeks over Christmas and New Year's in hospital recovering from a PE. I'm sorry to hear that. Because COVID, no visitors. By the end, I had a 3-day long panic attack. I was 40. Maya was 10. Yeah, I mean, one of my earliest memories is of being in an oxygen tent, and I can tell you that is freaky because you're on your own and so forth. I feel a strange disturbance in the thirst. I love it. Brewberry says, "I'm doing science and I'm still alive." Music note, cake. I love that game so much. Sandy, thank you for 5 gifted memberships. Much appreciated. Willie Czar says, "New fan here from the USA. Welcome." Rhineman YYC says, "We need an extension on that RFP. Shredder overheated." Nice. Rob, thank you for 20 gifted memberships. Much appreciated. And Emma Z, thank you for 5 gifted memberships. All right. The next thing I wanted to cover. Oh, and people were asking, like, what kind of spicy things does Runkle like? So I've still got some of these. And if you're wondering what the red things are floating in the bottom of this, those are Carolina Reapers. Carolina Reapers are peppers that they don't mess around. If you are not familiar with real serious heat, Carolina Reapers deliver all the heat. They will hurt you real bad. So I threw those in with some pickled beans, and I call them nuclear beans. They're really good. They are fantastic. And we've got Rob with 20 gifted memberships. Thank you so much. And we're at a very special portion of the day. That is we are now at spicy time. All right. That was the wrong swoop, by the way. That was not the one I wanted to play, but it is still a spicy time swoop. Maybe I'll play the right one too. That is the one I wanted to play. But so we've got and thank you, Nancy Robbins, for 50 gifted memberships. Thank you so much. That's very generous. Thank you. All right, let us cover some Freeman on the Land updates. And one of the things that's wonderful is just how bizarre these get. So let us start with, and we're just going to look at this one here. This is the matter of the King and Jason Peel Smith, which will actually work way better if I actually put it up on the screen, because you guys can't read out of my imagination, as it turns out. So here we go. The King and Jason Peel Smith. This is not the Freeman lawyer one. That one is still out for decision. This is a Freeman tattoo parlor person. So he owns a tattoo parlor called New Dimension Tattoos, which is located in the city of Calgary. He had a city of Calgary business license and had operated without conflict with the authorities. He had dealt with Alberta Health Services inspectors on multiple previous occasions without incident. And then what happens? Well, somewhere along the lines, he gets some notions that are sovereign citizen notions. And that doesn't work out so well for him. So some inspectors showed up from Alberta Health Services and 2 city police officers. And so they wanted to, they got a complaint that persons had been unmasked in the premises, contrary to the COVID protocol, which was then in place. So this is also kind of a COVID case. So basically they said, listen, people were showing up and they're unmasked. That's not cool. That's not allowed. And you can't do it. So they had something in mind for how to deal with with COVID complaints. Now I'm just going to note, a bunch of people have beaten the COVID lawsuits or the COVID charges on their merits at this point, at least the ones in Alberta. But this guy is not going to try to beat it on its merits. He's going to try to beat it with Crazy Town. And Crazy Town does not work as well. So Kent responded, that's his wife, Sarah Kent, responded that the officer needed to read 2 notices that were posted outside. They had anti-cop notices that said that they needed to show proof or that they were trespassing. She said that they were under common law. Now, it might have actually been that they were, it might actually be that they were, that his wife got the sov sit notions. I don't know. Like, I don't know how that happened. So, Ms. Kent then got a man called Marco on the speakerphone. The accused admitted in testimony that Marco was speaking with his consent and on his behalf. Marco told the officer that the COVID protocol had been notified by Section 51 or 2 sub 1 of the Charter, and that this had been confirmed by the Supreme Court of Canada, and that they were committing an act of treason. Now, I'm just going to say, folks, the police violating your charter rights is not treason. I mean, it's jerky, but it's not treason. So, he added that the bylaw violated the charter because the premises were private property. I mean, lots of laws affect things on on private property. For example, like, I am not allowed to have, say, cocaine. Even if I wanted to have cocaine, which I don't, I'm not allowed to have cocaine in my, and I'm certainly not allowed to like grow opium poppies or anything like that. Even if I do it on private property. Lots of laws apply on private property. The officers and Marco then spoke over each other, making it impossible to hear what each was saying. However, one of the officers eventually asked, "Can I look?" And they said, "Did you bring proof?" And the officers left without inspecting the premises. So, the accused argues that the attempted search of his premises violated his Section 7 and Section 15 sub 1 charter rights and was a trespass on his private property. He argues that both the COVID protocol set up by Alberta Health Services and the city masking bylaw were invalid because of the provision of Section 52 sub 1 of the charter, which provides, this is a critical portion of the charter, which they spelled in this decision as the chatter, but that's beside the point. It's the Charter of Rights and Freedoms. The Constitution of Canada is the supreme law of Canada, and any law that is inconsistent with the provisions of the Constitution is, to the extent of the inconsistency, of no force or effect. What this law means is that if the government passes a law that is unconstitutional, that law doesn't apply. The problem is that there's lots of laws that allow them to search your business. For example, if you are running a restaurant, the health inspectors are entitled to come into your restaurant to make sure you don't have, like, make sure that the meat isn't sitting in the sun. Make sure you don't have roaches or rats or mice or lemurs, whatever might be infesting your property. Make sure you've washed the dishes and you don't just like put new food on dirty dishes. Like, all of these things, right? All of these things are just part of the law. So, yeah, and that's to be expected, right? Because we don't actually want a world where you go to a restaurant and you end up and you find out that there are lemurs infesting the back. I don't know how that would happen, but I mean, you don't want lemurs to be running around in the back, pooping on things. That's not good. Lemur infestation is a growing problem. So, yeah. So he's saying that the bylaws are not appropriate. He further argues that his premises were not a public property and the officers were therefore trespassing. He states that documents should have been shown to him to justify their presence at his business premises. So he doesn't just want the charge to be dismissed. Like, regular people would argue a charter argument and say, because of the charter argument, I want these charges to be dismissed against me. I should go free. Like, I shouldn't have to pay any fine. He also wants to get paid. And not just a little bit. Like, he's doing the meme with like the hand pointing into like, he's going for like all the money. He's saying that he wants $140 for legal fees. How is legal fees the lowest cost on this? Because I can tell you, as a lawyer, I'll do stuff for free. I will not do stuff for $140. Like, $140 isn't get me out of bed money. It's not worth opening the file for $140. Who's he paying? Like, what kind of cut rate lawyering is this? You know, this is like, is this a lawyer you found like passed out in a phone booth somewhere? You know, if you could still find a phone booth. Like, all right, $3,500 for missed wages. So his wages are more than the legal fees. And to be awarded $400,000 for trespass. I can tell you there's never been a $400,000 trespassing case. Probably. I mean, maybe if you trespassed like onto an airfield and like prevented an airplane from taking off or something. I don't know. $50,000 for emotional and psychological distress. How sad did this make you, sir? Like, how sad? $100,000 for violation of Section 15, Sub 1 of the Constitution Act. That's for discrimination, and $200,000 for violation of Section 7 of the Constitution Act. There was a guy who was wrongfully arrested by the police, and the court awarded him like $2,000. And that's a guy who was like thrown in handcuffs and then thrown in the back of a police car. You get less than these amounts if the cops beat you up. Yeah. Somebody says the $140 could be the cost to file. He was charged. He shouldn't have any filing expenses. Yeah, I don't know. Notices. The accused relied heavily on 2 notices that he'd posted at the entrance of his business. And this is a really common sovereign citizen tactic. They love doing this. And they're always wrong. So the first, headed no trespassing, demanded that anyone acting for a service corporation provides proof that an obligation exists with service corporation to jurisdiction over my property. They don't have to provide you proof. They just exist, right? They just exist. And the notice provides a trespass fine of $100,000 for the first trespass and an increase of $200,000 for each additional trespass. The second notice is to all members of the Crown and all public servants. It advises that the occupants waive their right to be recognized as legal persons before the law. They should actually be glad that that's not the case because, for instance, the law prevents the police from, beating up persons. So maybe you want to be a legal person, so they're not allowed to like kick your teeth in. But you can't actually waive your right to that and claim their right to be recognized as human beings. They're the same freaking thing, my dude. It advises that they choose not to associate or belong to any society. Then you need to move into the forest. I mean, that doesn't actually work. You can't just move into the forest and suddenly be not bound by any laws. But, I mean, you do want to be recognized, like, to belong to society. Any action limiting human right was to be dealt with immediately pursuant to 24 sub 1 of the Constitution Act of Canada, 1982, and was to be considered treason against Her Majesty. So, this is something they often try to do. They try to create these like foisted obligations where they just tell the world that the world is going to owe them something. You can't do this. Like, you can't just say, hey, I'm going to run a meth lab out of my basement, and any police officer who wants to investigate my meth lab owes me $10 million. Like, that isn't how the world works. You can't just, like, create some magical contractual barrier against police enforcement. Yeah. So they note that this is elements of the philosophy of organized pseudo-legal commercial argument which means like sovereign citizen BSery. One of the most prominent is his demand that he be paid $400,000 for trespass based on a no trespass notice. So Justice Rook had referred to attempts to create legal obligations for others that interact with the claimant. He states, "This is, of course, nonsense." Jen says, "I got 2 tattoos there. Glad I found a new place." Yeah, I would not go to a tattoo place that like tries to repel health inspectors. I want my tattoo place to be inspected by health inspectors, to be like, "Hey, do you have an autoclave and does it work?" Thank you so much for the membership as well. Like that. But yeah, do you have an autoclave? Does it work? Do you sterilize your tools? Do you use single single use tools? Do you use any of these things? Yeah. And Judy, you got this. As Artie's corporate fiction knows most of the theories and gurus. He would be a great interview. He absolutely would. I just sent him the documents just recently on the BC Sovset. Justice Rook in Meads versus Meads point out that OPCA adherents often demand the Crown provides proof that it has authority to proceed. Yeah. So the court is going to dunk on this guy. Why are they dunking on this guy? Because he's ridiculous and he's silly and he deserves to be mocked. So ironically, one notice denies the right of anyone or any society to impose obligation on them, and the other purports to impose obligations on others. The shorter one insists that any public servant prove the existence of a contract between society and the accused, and the last sentence seems to unilaterally impose obligation on others without the existence of a contract. Oh, I love you, Judge. I love you. That's beautiful. Pick a lane, sir. And so he addressed this type of document, or Justice Rook did, saying, "What is the value of this document? Nothing. It's just another foisted unilateral agreement. Courts have uniformly refused to enforce agreements of this kind." So you can't unilaterally impose a system of fines and sanctions on others, unless you're the government, right? The government can. People can't. So the accused also claims to be able to choose not to associate or belong to any society. This reasoning was rejected by the courts. You cannot opt out of the operation of legislation, which makes sense, right? Because otherwise I could be like, "Hey, you know what? Murder rules don't apply to me, so I'm just gonna go shoot some." Like, no, you can't do that. That is not how things go. You can't be like, "I love meth, therefore I'm just gonna make some meth in my basement." These are not things you can do under the law. Accordingly, I find that the accused is bound by the same laws as the rest of us. In case he feels aggrieved by having to remain in society, I would point out that belonging to society has certain benefits, like fire protection and a functioning monetary system. The authority governs property owned by private citizens. None of these guys who want to be like free of the system also want to stop using things like money. I mean, I might have more respect for them if they were just like, "I'm going to conduct all of my transactions in gold." But I can tell you what happens if somebody comes up to me and is like, "I would like to transact business with you in gold," which is, I will say, that is a very nice idea. Please take it to someone else, because I don't have the ability to test gold. I don't have the ability to, like, I'm not going to weigh gold out. How much gold does it take for like one banana? I mean, if we're using the Arrested Development meme, one banana, how much gold is it going to be? Well, I can tell you, it's going to be a real tiny flake. Yeah. All right. So, now the government tries to pull a fast one here, and the court actually shoots him down, shoots the government down. So, they basically say, that for me, really, all of the other points that to me, 15.1 is really where I feel as though my human rights have been violated. So what does the government argue? The government argues, well, that they abandoned all charter issues other than Section 15.1, and therefore they don't get to argue Section 7. And the court says, listen, I'm not going to take this as being that specific because this guy is a self-rep. He's on his own. He's on his, this guy is a self-represented person. We're not going to be that technical. Yeah. But, so he's allowed to argue Section 7, which provides you with the right to life, liberty, and security of the person. And the court says he's allowed to argue it. I'm going to consider it. And the consideration is, in the present case, the accused's life, liberty, and security of the person were not at risk in any way. Done. Done. Section 15.1 provides that you're entitled to not be discriminated against. Cool. He says he was discriminated against because he was being forced to wear a mask despite having a medical exception. However, the inspection was of his business premises, not of him personally. There was never any suggestion that he was going to be charged with not wearing a mask. So that doesn't apply either. It's just of his business. Yeah. They say, they say basically that if he'd allowed the search and had been charged for violating the masking protocol, he could make this argument. But he can't do that. So, no. So he gets found guilty of the charges under the bylaw, and he dismisses all of his claims for damages. So this guy has to pay a small fine. A small fine. Now, this is not the worst thing that happens to a SOV citizen this week. Because it gets worse in the world of sovereign citizens. And that's like just from this week. Royal Bank of Canada and Anderson. And note, this is the style of cause. So, Royal Bank of Canada and this big block of text and Attorney General. Let's read the style of cause together because, oh my God, it's hilarious. And by hilarious, I mean, why, God, why? Now, you might recognize this particular crazy person because I covered her before. She's still going. So she is Sandra Ann Anderson, a.k.a. Sandra-Ann, authorized representative, a.k.a. Sandra-Ann Anderson, or Anderson, a.k.a. Sandra Anderson, woman Sandra of the Anderson family, a.k.a. I, woman Sandra Ann, acting as agent for and on behalf of Sandra Anderson. Now, if the I, woman thing, how many people find the I, woman thing familiar? Because that's familiar. The BC lawyer who's doing the SovCit thing is doing the I, woman thing. Yeah. A.k.a. Sandra Ann woman, a.k.a. Sandra Ann executor, a.k.a. Sandra Ann, a.k.a. Sandra Ann Anderson, a.k.a. are all rights reserved. Seski keys use, principal beneficial owner, a.k.a. Sandra Ann ambassador, a.k.a. I, Sandra Ann Anderson, child of God, a.k.a. Sandra Ann from the House of Anderson, a.k.a. Sandra Ann Anderson, authorized agent and beneficial owner of the trust known as Anderson Sandra Ann copyright symbol trust and estate. Whew. Now somebody says, "Oh my God, does this mean we get no punctuation, no anything?" No, because this is actually authored by the judge. So we're going to get grammar. And if you've seen the filings by the woman out in BC, you will know how important grammar is. So, Ms. Anderson is a highly active, abusive, organized pseudo law commercial argument litigant. Now, there are some important things. She has been involved in some, some issues there. So, because of that, the court basically grabs a bunch of her money. And why do they grab her money? Because she is, they're worried that they're going to try to punish her by setting fines against her and that she's not going to pay them. So she is, she's got an inheritance that's due her. That inheritance is $650,000. Chat. I do not have $650,000 on hand, but she was going to have $650,000. Her inheritance was going to pay her $650,000. You know what you do if your inheritance is about to pay you $650,000? You say thank you and you take the money. What does she do? She does crazy things. So, what kind of crazy things? Well, she starts filing stuff. She comes to the court and she gets immediately dinged on June 11th. She's asked to pay $27,500 in costs for being a crazy sovereign citizen. Later on, she is awarded, or there's $2,000 in costs against her. That continues on. So they get another costs award of $31,497, and she has at this point diminished her pool down to $364,730.68. That continues down. She gets another order against her of $31,497.13, reducing the amount that she's going to get paid to $333,000. Then later she gets $55,000, dinged on her, which takes her down to $278,000. She started out with $650,000. She's now at $278,000. She spent $400,000 on pissing off the court. Now, I mean, there's all sorts of things you can do with $650,000. But just pissing off the court is not how I would spend $400,000. And the court's like, stop, you're already dead. But she keeps going. So the court wants to throw out a bunch of her stuff. I'm not going to go through it in full detail, but we are going to cover some of the highlights, because there's some highlights. And by highlights, I mean, oh my God, what the hell? So her first complaint is that she should be able to appear remotely via WebEx instead of in person. She was told to appear in person. So she says she doesn't want to. So there are some reasons for that. And she also says that she's getting unlawful violence and threats from the sheriffs and law enforcement. But she doesn't provide any evidence to substantiate those claims. She doesn't say when and where and how these two events transpired. She does not provide dates or who was involved. Her materials do not include any evidence of complaints to any authority or agency that responds to potential peace officer misconduct or criminal activity. So you want to say that they're beating you up, maybe you should actually, call the cops. However, she has a record of problematic and disruptive in-court appearances. Her conduct has required the sheriffs to intervene and eject her from the court center, along with her private sovereign, SOVRAN, Attorney General, Daniel Terry Lozanik. So that guy gets yeeted, and she gets yeeted, and they're saying, hey, yeah, you're on notice that they want to bounce you because you're behaving really badly. But she's also facing multiple criminal proceedings in the Alberta Court of Justice, including the following. Somebody says this isn't the same person with the privacy walls. No, she's making some similar arguments to the same person as the privacy walls. Now you might be saying, a nice person like this, how could she possibly be facing criminal charges? Well, it's true, folks. I regret to inform you that this very nice person is, in fact, facing criminal charges, which include driving while impaired, failure to provide a driver's or produce a driver's license. I'm guessing she might have had, some other weird driver's license, but I don't know. And operating a motor vehicle while having a prohibited blood alcohol concentration. So driving drunk, uttering a forged document, forged COVID-19 test results, and transporting fireworks on an aircraft. That's a hell of a combo. I mean, so she's faking a COVID-19 test result in order to get on the plane, but she's also transporting fireworks on that plane. Pick one. Both are crimes, right? Both are bad things. Do not do both. But one crime at a time is kind of a thing there. Fireworks on the aircraft. Now, I'm just going to say, the thing about fireworks is that they are at best pyrotechnic material, as in they catch fire and burn real good. And at worst, they're things what go boom. They don't typically let you have things what go boom on a plane. In fact, they're very particular about it. It's very, very particular about no boom on the plane. So, yeah. Customs and fraud offenses resulting from Miss Anderson's international horse smuggling. How? How is she how is this the range of crimes? Because I'm gonna say, lots of people do crimes and get into all sorts of trouble, but the range of this is A, drunk driving, lots of people drunk drive. I'm not saying it's okay. I'm just saying it is a bog standard, really common charge. Lots of people drunk drive. It is just how things go. That's just part of society. Transporting fireworks on an aircraft is okay. That's news. International horse smuggling. Is she like an old time cowboy era bandit now? Failure to attend court. Okay, now we're back into usual stuff. Failure to comply with the release conditions. Okay. There's some weird stuff on that though, right? So, Ms. Anderson has not appeared at scheduled criminal court appearances before the Alberta Court of Justice. Further, she is the target of multiple arrest warrants. You know how she didn't show up? You know how she didn't show up to court? And she wanted to appear on WebEx? It might have something to do with the fact that she's got arrest warrants out for her. So, yeah. This court has previously concluded that she absconded from Canada to the U.S. to evade arrest and detention in her criminal proceedings. But she's now in Calgary, Alberta. I'm sure Calgary is so happy to have her. So, based on the evidence before me, I conclude that Ms. Anderson faces no real threat of being illegally assaulted or harmed if she attends Alberta court proceedings in person. However, she will probably get arrested. I infer that this is the actual reason Ms. Anderson wants to appear remotely. In my current view, the current situation is Ms. Anderson's choice. She chose not to attend the Alberta Court of Justice proceedings against her and breached her release conditions. Ms. Anderson has no one to blame but herself. If she wishes to address her outstanding arrest warrants, then she should retain a defense lawyer and surrender herself to law enforcement. 1, 2, 3, not it. Not it. Like, the sad thing is I probably would actually take the file. I might have a conflict given that I've made fun of her. But not it. I would have, if she came to me, I'd have to be like, so before we do this, you got some videos to watch to decide if that's something you want to do. And they're going to be awkward because I got to say it would be really, really awkward to be watching this video right now with her. Yeah. Now, Ms. Anderson is unable to retain counsel. Ms. Anderson in her affidavit states she's tried to hire lawyers, but they refuse to accept her as a client. I wonder why. She includes several email exchanges with law firms and lawyers to that effect. I do not find that a reasonable basis for the proposed application. I make this determination because the court has taken no steps to limit or order lawyers practicing in Alberta not to interact with Ms. Anderson. Previously, judgments have observed that Ms. Anderson was having Alberta lawyers breach their professional duties, legislation, and the instructions of the Law Society by notarizing OPCA documents, which you're not allowed to do. As a lawyer, you're not allowed to help these people like commit crazy at the court. Yeah. A penalty was imposed against a lawyer in one instance for that misconduct. So a lawyer got punished. Now, the court also notes that what lawyers will refuse to do, as they must, is participate in and advance abusive OPCA schemes. So there's probably lawyers who will take her file. They just won't take her file and argue the stuff she wants to argue. Yeah. All right. Now, they also note, and I love this, third, when it comes to retaining a lawyer, there are plenty of fish in the sea. Ms. Anderson is not a destitute person, i.e. she's still got $250,000. If Ms. Anderson wishes to engage a lawyer, she will benefit if she makes a clear break from her prior illegal and abusive pseudo-law litigation strategies. Whether that happens is up to her. I.e., if she comes to court and is like, or comes to a lawyer and is like, I screwed up. I did all the bad things. I want to do the right things and do the right law things. And I have $270,000 to do it with. A lot of lawyers would be like, yes, please. We'll take that. Like, we like money. We like all the money. So, and I mean, wouldn't you? So some lawyer will be happy to say, listen, here's my hourly rate. We're going to start trying to un-F your life. Cool. But yeah. However, they also note that most lawyers will be alarmed by the implications of Ms. Anderson's record of adopting fictitious lawyer personas to interact with the court. And you might be saying, as I was doing, dude, because fictitious lawyer personalities is a hell of a thing, right? She's inventing lawyers. So let's look at that, because that's fun. That's spicy. Yes. All right. So in docket number 3, I strongly recommended that if Ms. Anderson does retain a lawyer, that she show the litigation record and resulting judgments, and then listen to the advice offered by that lawyer. So, what is it? Now, where did the lawyer thing go? Oh, we got it skipped over here. So, during the July period where Ms. Anderson was telephoning the court, Ms. Anderson reported that she'd be having her unnamed lawyer engage the court. And the court went, thank God. praise Jeebus, praise, Odin, praise every god that has ever been imagined, and, every god in the sky and the earth and so forth. She's got a lawyer. Thank you, thank you, thank you. And apologies, that was probably fairly sacrilegious, but it is what it is. She then, the court gets an electronic document that instructed court documents be sent to Erica Health and delivered to a post office box in Calgary, though the customer's address was instead in Wellington, Florida. This request was rejected by the clerk of the court because she hadn't followed the communication protocol, because she's on strict litigation rules. Next, Erica Health, on August 14th, wrote the clerk of the court by email using a Gmail address, lawassistla@gmail.com, that was also on the July 27th document request form. Thank you for your prompt response. Can you please provide me with the reason/law for not providing information as to whether case number 221-08392 is still active or withdrawn? I'm not as familiar with Canadian law, but in the USA, all cases, unless sealed by the court, are open to the public to view. In addition, the memorandum of decision/order does not list anything about preventing public access to any documents regarding the case. Thank you again, Erica. Now, you can order... Oh, and Rob is saying, signing off, CT in the morning, court in the morning, good night all. Get some rest, man. That's important. The court responded by email to Erica Health and confirmed that this court records are public, clarified the restrictions on her interactions with the Alberta Court of King's Bench, and said, if you are a lawyer who is representing Ms. Anderson, please provide your Law Society information to verify your status, since no one named Erica Health is an active member of the Law Society of Alberta. So, to act as a lawyer, you have to actually do the lawyering things, right? You got to go to law school, you got to get, approved, you got to everything, right? So, there was no reply from Erica Health. No one named Erica Health is registered as a member of the Florida Bar. However, the same day, a further second document request was received in relation to one of Ms. Anderson's legal actions. The two document requests sought the same materials. This time, the search was submitted by Lynn Ross of Ross Law, who on the document request form provided two Lethbridge, Alberta addresses. Again, the email address used was not that of a law firm, but llhtrustee@gmail.com. So RBC versus Anderson number 2 permits a lawyer qualified to appear in Alberta courts and who is representing Ms. Anderson to directly contact and correspond with the Court of King's Bench of Alberta on her behalf. So they contacted Lynn Ross by email and they asked for her membership number to say that her request is valid, and they got no reply. There is no lawyer named Lynn Ross in Lethbridge, and there is no firm Ross Law. Then Erica Health reappears to say, I am a lawyer, but not with your Law Society of Alberta, and stating that Ms. Anderson should not be penalized because it was Erica Health who made the request. Ms. Anderson did not request that I contact the court for this information. I did that on my own. It was my error. So they ask her so the court says, cool, you're an American lawyer. Great. Give us your U.S. Bar Association directory registration information. And yeah, it was an issue there. What is it? So let's see it. We're just looking here. What is it? So this further warrants some penalties. So she ended up having to pay a bunch of money. Now, getting back to her current decision, she makes a bunch of stupid arguments. But we get to the end of all of this, and they say, we're throwing out your arguments. But they don't charge her any additional money. They don't charge her any additional funds because they say, we punished you enough, and you're at least trying to argue things correctly. So, yeah. Strict litigation rules. Would you explain? They put her on rules about how she's allowed to communicate with the court. They put her on rules about how she's allowed to file things. They put her on all sorts of rules like that because she is a crazy person who is abusing the system. So that's how that came to be. So yeah, that is the fun one there. What is it now? Or that is a fun one. There are some other fun topics I wanted to talk about here, and I'm just trying to pull it up here. Give me 1 second. I have got way too many tabs open. I am bad at tabs. Like I just opened too many tabs. Where is that one? It was a good case. I want to cover it. It is about a rental car, and I want to talk about rental car rules and how much you can get. You know, what should happen if, certain things go down. All right, let me just, you know what? I'm going to have to find it via, there we go. Boom, here we go. This is a CBC story. CBC does some good coverage. They're not all bad. So, budget car rental blames possible tire thieves after SUV sends driver and kids spinning out of control. So, what happens? Well, this guy and his 2 kids were off. They wanted to go and see their favorite YouTube stars. And you might be saying, oh, cool, they wanted to go see Runkle. That is not the case. They wanted to go and see the Sterniolo triplets, who have 5.5 million subscribers. I am not one of those subscribers. I don't know who that person is. But they wanted to go see those people. And so they wanted to rent a vehicle, a newer and safer vehicle than he owns, in order to make the 1,500 kilometer drive to Minneapolis and back. And this is what happens. Their car ends up spun out on the road. And this is the tires that were on the car. This was just the back tires. Now you might notice something about these tires. These tires are so bald. Mr. Clean has more hair than these tires. Like, these tires aren't just bald, they are polished. There's not just no treads on this. There's like they apparently got rented this car with no tires, and the franchise owner was not checking these ahead of time, but blamed tire thieves. Now you might be saying, tire thieves? Yeah, that's a thing. There are people who steal tires off of cars. They rent the car. They then go and, they then take, the tires or something else off of it. And then they just, that's it. So, that's what they're blaming. Now, here's the fun thing is that ultimately at the end of the day, if you're renting out the vehicle on that, you're still liable. So, but this is a really good reason why you should check your car. Why you should check your car when you are renting it. I rented a car when I was when I was in San Antonio. And the first thing I did was I went over it and I actually took some pictures of some things that were damaged. So, but you don't just take, you don't just check it out just to be like, hey, are there dents? Are there dings? You should also check it out to be like, hey, do the brake lights light up? Do the brakes actually engage when you press the brakes? Are the tires something that exists, right? Check the car because it could get you killed. And TMC Mommy says, well, shoot, I missed you in San Antonio. I'm in Austin. I did a meet and greet out in San Antonio. It was on short notice. Next time I'll do one on a little longer notice, and hopefully we'll get to meet up. So now I see people saying every rental I've done require a walk around with the rental agent. When I did this one, I got it with the insurance, the loss damage waiver. And what is it? The loss damage waiver basically allowed me to, when I had that, they're like, we don't care about doing a walk around because you don't owe us if you don't find for any damage to it. But I still do the check because I want to make sure it's okay, right? I want to make sure I'm not going to die. The rental car should be doing the checks, right? They should be, rental car should be verifying this stuff, or the rental car company should be verifying this stuff, and they are not. All right. Let's talk about, I guess, one last case. I'm running out of steam. I'm still not up at 100%. I've been traveling. I have all of this. So I am still doing what I can do. So I'm going to give you guys a choice of what we're going to cover. Do you guys want to cover illegal potatoes? Option number 1, illegal potatoes. Option number 2 is guy charged with second-degree murder for selling a food ingredient. And option number 3 is still a cop versus not a cop no more. What do people want to do? So 1 for illegal potatoes. And I will set this up as a survey. I'm realizing I should do this as a poll. So options: illegal potatoes, second-degree murder, or still a cop. Boom. There we go. Poll is hopefully going up. Assuming I don't suck at this. Can people see the poll? Can people see the poll? I'm not seeing the poll. Hopefully you guys see the poll. All right. Well, I'm seeing a lot. Oh, there we go. There's the poll. The poll is not working great, but I just see it now. Illegal potatoes is off to a tremendously large start. Crime taters. Okay. I guess we're covering crime taters. Because they've got 67% of the vote with 200 votes in. I'm just trying to do this real quick, so we're going to end the vote, and we're going to cover crime potatoes. So, crime potatoes. BC farmers growing outlawed potatoes are looking for new partners. So, these are farmers holding potatoes that are they're called the caribou potato. And the caribou potato is, they're a potato. And they're a potato that is specifically bred for use in this particular region that they live in. Why are these potatoes illegal potatoes? Well, these potatoes were declared to be basically a species that you're not allowed to grow commercially here in Canada. So, what does that mean? Well, it means that the government regulates, and people are saying part caribou. There's actually a caribou region in Canada, and they were grown to be, for that area. So, they are, a yellow skin with beautiful pink blotches, they say. So why did they ban these potatoes? Why are these potatoes illegal? Well, these potatoes were barred because they're crappy for commercial use. And what I mean by that is that these potatoes have a couple of qualities that were considered to be non-ideal. So they were removed from the list of potato species that you're allowed to grow commercially. So what are the qualities that make them bad potatoes? Why are these misbehaving potatoes? The first thing is that these potatoes do not grow or do not survive well if you keep them in sunlight. If you keep them in sunlight, they go bad. So you got to store them in the dark. And you might say, well, don't people store potatoes in the dark normally? Well, yeah, I would. But you know who doesn't store potatoes in the dark? Supermarkets. Supermarkets want to sell the potatoes. And so they keep them out in the light so that some random person can walk by and be like, I would like to buy this potato here. Nobody goes and buys potatoes in the dark. And because these potatoes are vulnerable to light, they say this is not a good quality. And there's a further issue with them. The potato plant itself, the plants that stick up out of the ground, right? Those plants have all sorts of little feathery, weird fringes and fronds and so forth. So these are not considered ideal because there are machines that you use in order to gather potatoes. And the reason why these machines are, why this is a problem is that all these little feathery, frilly, bits clog up those machines that otherwise allow you to harvest the potatoes mechanically. You got to harvest them by hand. Now that's fine if you're growing like your individual potatoes, but it's terrible if you are trying to grow these, commercially. Now, this is the question I was hoping somebody would ask, and it comes from Koru. Shouldn't it be up to the farmer? Well, two things. One, they keep this as a list of like, these are the things that are, that are commercial and so forth, or that are viable. But the other thing is they don't want people growing lots of these potatoes because they're really worried that like the neighboring potato place that might be growing some different variety is going to pick up genetic information, going to crossbreed with these potatoes and might suffer some additional problems. So like, let's say you are, your big potato, the big potato, your big industrial potatoes. And so you are the big potato growers. Well, you're going to be really upset if suddenly your potatoes start to hybridize, or get whatever, get pollen from, other potatoes. I don't know for certain if that's the reason. I suspect, but it may just be that they are like, we consider this to be not a commercially viable potato. But there are apparently big fines if you grow these potatoes commercially. And I gotta say, I have never wanted a potato so badly as I want these potatoes right now. I want to go buy some potatoes. I want to grow some potatoes just because the government doesn't like these potatoes. It's like, I kind of want to be like, so I'm thinking maybe I'll make a shirt that is going to be a really subtle reference. It's just going to be like a blotchy potato with a sign or with a thing that says become ungovernable. And yeah. Now, this is a good question from Kestrel saying, but we can grow them as hobbies. Yes. You just can't grow them commercially. So you can have these, you can have these casually. So I might have to make a shirt that says become ungovernable and it's just a potato. So yeah. Oh, and Cat W, who I met and is a lovely person, says, thank you for taking the time to meet up while you were here. I really enjoyed the meetup. I had a great time. Hopefully I wasn't a jerk. I try not to be a jerk. It was lovely meeting people. We got a little bit more time, so I'm going to ask again, just really quickly, and just type it in the chat. I'm not going to mess around with the poll because the polls are a pain. 1, second degree murder for food ingredients, or 2, still a cop versus not a cop no more. So I'm just looking here. I'm seeing some 1s. I'm seeing some 2s. I'm just gonna basically ballpark it as to what we're seeing here. 1s and 2s. This one's kind of even, but I feel like the cop is slightly ahead. I need a free the tater shirt. Fair. Screw it. It's really even. We're going to do both really quickly. All right. First one up. We will just do this one first, and we'll do the still a cop versus not a cop no more last. So Kenneth Law, which is a guy. Kenneth Law has been accused of or charged with murder, 14 counts of second-degree murder, in addition to 14 counts of counseling or aiding self-deletion that he was already facing. So why is it second-degree murder? Well, they're saying basically that he did an illegal thing that he knew or ought to have known should have caused or would have caused people's deaths. And what is it that he sold? Well, he sold a food preservation thing. I see people saying embiggen. I'm actually going to insmallen. I'm going to remove. This guy is a chef, and he sold a food preservation ingredient that I'm not going to name. That is why I'm removing. Because the CBC article actually names the ingredient. He sold this ingredient, which is used for, just food preservation. It's fully legal. It is in a lot of the stuff that you eat. It's in a ton of the stuff you eat. But he sold this as a means to aid with self-deletion. Somebody says, give a clue. It's in a lot of preserved meats. That's as far as we'll go. Now, he has been linked to deaths in a variety of countries. They say that he sent over 1,200 packages to people in more than 40 countries. And basically, he was advertising this as a means of self-deletion. So this will be an interesting, and somebody said MSG, I bet. It's not MSG. Now, and this is, somebody in the chat said this, and this is really, a good comment here. Dose makes the poison, because there's lots of things that are poisonous in quantity. In fact, just about everything is poisonous in quantity. Water. You can be poisoned to death with water. You can be poisoned to death with all sorts of things, like caffeine is poisonous. You can't really poison yourself with coffee or cola, because the amount of cola you'd have to drink in order to to get enough caffeine to be dangerous would actually be too much volume for you to contain. But like people have died overdosing on caffeine tablets. Don't do that. And yeah, I mean, water, you got to really work at it. You got to like drink tons and tons and tons of water. Don't do any of these things. But so the theory basically is that this guy's liable because he was selling this stuff, knowing that people were going to use it to self-delete, and because he was encouraging them. And because that encouragement is illegal, because in Canada, in order for a death to be wrongful, it has to somehow violate a law. Now, I'm being reminded here, I should remind you guys to hit the like button. And if you haven't, hit the subscribe button. Like, that is a good thing. Yeah. All right. So that is what this charge is about. I'm really interested to see, there is some past precedent on this. And the past precedent is typically like drug dealers who are selling stuff that then later kills their clients. Ultimately, I think that this guy is likely to be in some trouble because they're going to want to hammer him hard. I don't know how much money he made on this one, but I suspect that he's going to spend more than the money he ever made on legal fees. And I also suspect he's going to end up doing a ton of jail time. So I'm going to try to follow this one up as I can because, I suspect this guy's going to get pretty much life in prison, and then a bunch of other places are going to pursue. Guys, do not talk about how to kill each other in the chat. That is not a good thing. I say, what is some guy called? Kenneth Law. The last name is really ironic, but he's Kenneth Law. You can Google the guy. All right, so last one is going to be depressing. We're going to send this out with a really depressing bang. And we got to run our Still a Cop swoop. And after that, we'll have super chats, which will hopefully be less depressing, but Still a Cop swoop. All right, so now it is time for the world's worst game show, Still a Cop or Not a Cop No More, where we evaluate. We look at a case and we say, is this guy still a cop or is he not a cop no more? And usually the answer makes us sad. Now I'm going to put up a poll. I've been requested to put up a poll. Don't vote until you have enough information to make a guess. So, hold off. You don't have to vote right away. You can save your vote until you got enough to make a guess. So, somebody says, where is this from? This is from Surrey, British Columbia. So this guy, Corporal Peter Leckie, had been a member of the Surrey RCMP since 2010. He pled guilty to 3 counts of breach of trust, but that is not all he was initially charged with. Now, they are noting that the sentencing submission recommends no jail time. That's not technically legally correct, in that the law considers a conditional sentence, which is what he got, to be the equivalent of jail time. Now, most people would prefer the actual conditional sentence, the house arrest, to that. Now, people are saying you already told us. Kind of. The depressing ending isn't that. It's what actually happens. So, this guy is investigating a woman who had sort of fallen into becoming a sex worker. She's 19 years of age. And so, 19 years of age is at least over 18, so that avoids certain things. But they note, and I'm quoting here from the CBC article, when they first met in 2014, Corporal Peter Leckie knew the young woman had recently experienced the murder of her father, a diagnosis of borderline personality disorder, and entry into the sex trades. So, yeah. This officer then decided to target her, and used information from police databases in order to get in touch with this woman and her mother. He appeared at her house under false pretenses in order to continue that. Somebody says, was he her pimp? No. He was just trying to engage in a sexual relationship with this young woman. Now, the good news, there is a bit of a happy ending. Apparently, this woman has left the sex trade and has been sober for 21 months. So she's gotten off drugs. She's like, that is fantastic. He calls up the mother. This is how he gains entry into the home. He calls up the mother to say, I'm concerned because there's the suspicious death of another sex worker that was going on. Can I meet with you? And the mother invites this cop into her home and speaks to him, not realizing that the goal on this one was to facilitate this relationship. Now, before he was originally charged, and I'll note that when he was originally charged, that anything that he did not get convicted of, he's considered legally innocent of. But his initial charges, he had 15 charges, which included sexual assault. So, yeah, I don't know. Now, together, the Crown and the defense proposed this was a joint submission for what's called a conditional sentence. And a conditional sentence order is considered equivalent to jail, but it's got 6 months of house arrest, followed by a year of probation. A year of conditions that are less than house arrest. It probably includes curfew and all of that. Now, most people, even though it's legally equivalent, most people would not say that it feels equivalent, right? And if you were asking me, which would you rather do? A year of house arrest or a year of in jail? I would choose the house arrest every day of the week. Sure, it might suck not being able to go to the bar, but house arrest typically also does allow you to go for work. And so if you're feeling cooped up, you can go work. It'll allow you like 4 hours to go shopping for necessities of life. You can't go shopping just because you want to go shopping. But you can go shopping for essentials, right? You can go shopping for food, for, stuff like that. But I mean, I could do a year of house arrest real easy. I got Alan Wake on my computer. I got all sorts of games on my computer. I'd just be like, yeah, no worries. So nobody ever chooses jail. But the reason why a conditional sentence is something to take seriously is that if you breach it, then you can go to real jail. Now, I'm sure I'm seeing comments, people saying, we were all on house arrest during COVID. Kinda, right? And I see somebody saying grocery, pharmacy, and doctor. There's a little bit more for necessities of life. Theoretically, necessities of life can include things like, maybe going to get heck, it might include like a new computer. If my job has me working from home and, and that. I see people saying Camelot raid. Welcome, everybody. I need to get in touch with Camelot because we were talking about doing a stream and I am awful at those things. So, now, as is usual, this officer had a bunch of, things or people who were calling up to say, hey, this guy is a good guy. He's so he's got a bunch of character references from his family and friends. His wife supported him, which is weird because if I was this guy's wife and he was trying to get with some other woman, um, I wonder why she's supporting him, right? Like that seems like a thing to maybe not forgive the guy for. Um, so his defense team said that in the years before the crimes, his close friend had been killed in a crash while on duty, and he was drinking heavily and cheating on his then fiancée. That's maybe not mitigating. Now, I'm going to quote from the CBC article here. They say both Crown and defense lawyers told the judge that while Lecky's crimes could cause the public to lose trust in police and lead to poor morale in the RCMP, he will have a better chance of rehabilitation serving his sentence under strict conditions in the community. And you know what? I'm normally all about rehabilitation. In this case, I say F it. The primary concern on this one really ought to be general deterrence. To say, hey, officers, you're going to get real jail if you do this. You're going to go to jail for a good long time. Because this involves like breach of the public trust. Certainly, I think that as a member of the public, and just about every member of the public should be concerned that, if police officers are using these databases to creep on your daughters, no, screw that. Screw that, right? So, oh my God, this one ticks me off. So let's see where the poll is at. As usual, the poll is at 73% for still a cop. And the answer is he's still a cop. He is suspended from duty without pay. So that is good. I'm glad to see that he's suspended without getting paid for this. And he's got a code of conduct hearing scheduled for next June. I'm going to say that he is unlikely to still be a cop. And if he is still a cop at the end of this, if in June they decide that he can still be a cop, he's still a cop now because they haven't had the chance to kick him out yet. I think they're going to kick him out. And if I was the judge, I would be like, yeah. I see people saying without pay, that's the shocker. Yep. One of the big things is that in Ontario, their law requires them to suspend with pay. So even if they commit tremendously horrible things, they get suspensions with pay. In BC, not as much. So at least he gets suspended without pay. Yeah, I don't think that this guy should be a cop because this isn't just that he did a bad thing. This is he did a bad thing and it involves abusing police powers in order to do the bad thing. So this one is kind of mixed. It's still a cop for now. But he might not be a cop in June. I'm going to follow up on this one. I'm trying to put it in my schedule to be like, hey, let's follow up. Because I will be so ticked if they're like, yeah, we're going to keep him. Because even if they say, hey, we're going to keep him and we're going to put him in a desk job, well, that desk job still has access to those police databases that he was abusing. Now, this is the next thing I was going to get to. Connor is asking, you can't get a prohibition order off a breach of public trust, can you? Nope. So he pled to none of the things that might have allowed him to get a firearm prohibition order. Because I would, if I was the judge on this one and they're saying, hey, he's pleading out, and there was a charge in there that allows for a firearm ban, I'd be like, hey, I'm going to make it real easy to decide if this guy can still be a cop. 2-year firearm ban. Or if I'm allowed, longer. And just be like, yep, you can't be a cop. But this is one of those things that really raises the question of how do people trust police officers? If you're a young woman and a police officer's like, hey, can I give you a ride home? It's late. This is not a great neighborhood. That should be something where the woman is going, oh, good. Thank God it's a police officer. Not, right? Yeah. Sheila, court reporter, says, I'm going to self-yeet. I've got depots tomorrow. Good news. I am also going to self-yeet here because I am running out of steam. I am still kind of worn out from flying. I went to sleep last night and I woke up and I just had this massive pain down my side from, from having been on airports and so forth. So, yeah. Anyway, I think we'll wrap it up here. I am going to cover some super chats here before we go. Law and Lumber, thank you for 20 gifted memberships. I know he's gone to bed, but thank you anyway. Jen says, I got 2 tattoos there at the health avoiding tattoo shop. Glad I found a new place. Absolutely. XCDA, happy December. Happy December. Lost in Law. I love the name there. I learned how important apostrophes are thanks to Ricada. I've seen student law papers. They are fun to read. Sometimes. I mean, I've marked student law papers. Usually they're not bad. Usually they're not awful. Nick Cressman, fireworks on aircraft. Insert video of helicopters shooting Roman candles. That would kind of be cool, but you got to get permits for that. Cat W, thank you for taking the time to meet up while you were here. It was a pleasure. Absolute pleasure. You need a free the tater shirt. I need to figure out a shirt for that. Become ungovernable and it's just a potato. Some Canadian co-ops mail free caribou potatoes. I might have to look into that because, yeah. Robert Zarung, thank you for 50 gifted memberships. Very generous. Thank you so much. And Devin says, check your Discord DMs when you get a chance. I will get a chance in just a moment. So thank you so much. Thank you guys. I'm going to, shut down here before I run out of steam entirely. Always a pleasure, being on with you guys. I really do enjoy these Monday streams. Cat W got a late super chat here. Had a wonderful time hanging out with everyone. Your hot sauce is fantastic. Thank you so much. I'm just not good with spicy foods. I knew what I was doing though. Had to try it. It was great to see you again. Come back soon. I'm hoping to. Next time we may have a meetup in an ice cream shop if we can. So, all right. I am going to roll the outro and see you guys next time. Cheers.